Just doing an audio test for Tracy before we start.
Sounds great.
Thanks. Good morning, everyone. We're on the record in the Colorado Public Utility Commission's proceeding number 25A-0194E. I'm Kelly Rosenberg, the administrative law judge assigned to this proceeding. This matter is regarding Public Service Company of Colorado's application for approval of its 2026-2027 Renewable Energy Compliance Plan, Dispatchable Distributed Generation Procurement Proposal, and corresponding modifications to its Renewable Energy Standard Adjustment and Electric Commodity Adjustment Cost Recovery mechanisms. This hearing was scheduled by decision number R25-0591-I, issued August 14th, 2025, as well as decision number R25-0854-I, issued December 1st. This hearing was scheduled as a remote hearing where individuals are participating from discrete locations. And I have a few general advisements for everybody who's participating. First, the commission records and webcasts all legal proceedings, including this one, and we have a court reporter present. To the extent you are able to speak at what might feel like a slightly slower pace than you are accustomed to, that would be great. Second, if I mispronounce anyone's name or if I use an incorrect gender pronoun, I mean no disrespect. Just correct me. I will endeavor to get it right from then on out. And third, I appreciate we don't know how long this hearing will be today, but as needed, we will take small breaks every couple of hours or so for the parties and for those behind the scenes making this all happen for us. And we'll also break for lunch as needed, again, depending on how this hearing goes. And I just want to mention finally that if you see me looking to the side or if it looks like I'm typing, I assure you that I am listening. I'm either looking at something directly relevant or I am taking a note about the matter at hand. And now a few preliminary items before we get into the evidentiary portion. First, I'd like to take appearances from all counsel who will be appearing today. And I'll address each party one by one. I know we have a long list of parties in this matter. So first, public service.
Good morning, Your Honor. And can you hear me all right?
Yes.
Great. I am Caitlin Shields with the law firm Wilkinson Barker Nauer on behalf of Public Service Company of Colorado. With me today are Ryan Servais, in-house counsel for Public Service Company of Colorado, as well as Lauren Caliendo, also from Wilkinson Barker Nauer.
Thank you. Moving on, staff of the commission staff.
Good morning, Your Honor. Justin Cox, Assistant Attorney General with the Colorado Attorney General's Office, representing trial staff of the commission, joined by Assistant Attorney General Ross Smith.
Thank you. Office of the Utility Consumer Advocate.
Good morning, Your Honor. Nice to meet you. It's the first time
Likewise.
I've seen you. I'm Michelle Singer-Nelson. I'm from the AG's office representing the Utility Consumer Advocate.
Great, thank you. Colorado Energy Office.
Good morning, Your Honor. Cynthia Vitale representing the Colorado Energy Office. I'll also be joined by my co-counsel, Jackie Colicchio.
Thank you. Pivot Energy. All right, we'll circle back. City of Boulder. All right, Energy Outreach Colorado.
Morning, Your Honor. Apologies, just a little delay. My name is Veronique Van Giem, and I am an Assistant City Attorney for the City of Boulder.
Western Resource Advocate.
Good morning, Your Honor and parties. Parks Brosa representing Western Resource Advocates, or WRA.
All right, SunShare.
Good morning, Your Honor. Michael Foote appearing on behalf of SunShare.
Colorado Solar and Storage Association, Solar Energy Industries Association, and Coalition for Community Solar Access.
Good morning, Your Honor. Ellen Howard Kutzer of the Colorado Solar and Storage Association, appearing on behalf of the joint solar parties or the associations. Thank you.
Great, thank you. Climax Molybdenum.
Good morning, Your Honor. Richard Fanyo on behalf of Climax Molybdenum Company.
Cloudbreak Energy Partners, LLC. All right, Green Latinos, Grid Alternatives, and Vote Solar.
Good morning, Your Honor. Jessica Herrera on behalf of the EJC, the Environmental Justice Coalition.
Good morning. And I just want to circle back to see Pivot Energy. And Energy Outreach Colorado, is that who? I apologize. Ms. Van Geen, you are with Boulder, correct?
That is correct, Your Honor.
Sorry, I had an error in my notes here as I was doing this. Energy Outreach Colorado.
Good morning, Your Honor. Casey Canelio of Canelio Consulting here on behalf of Energy Outreach Colorado.
Thank you. All right, so it looks like Pivot Energy is not present. I just want to note that for the record that Pivot Energy has failed to appear for the hearing, but if Pivot Energy shows up later, we'll deal with that then, or acknowledge as needed then. Okay, and so now I want to discuss a little bit about exhibits. Oh, yes, Ms. Kutzer.
Thank you, Your Honor. While I don't directly represent CloudBreak or Pivot Energy, if the counsel for those parties do need to make an appearance, I'd be happy to contact them and ask them to make sure they'd sign into the hearing. I think they were under the understanding that that wasn't necessary today, but happy to help with that since they are members of COSA.
And thank you, and thank you for clarifying as well, as I had missed that CloudBreak as well. I didn't say them just a moment ago. I don't necessarily think that it's necessary that they be here, just to the extent if I were to ask a question about a settlement agreement and they would not be able to give the opportunity to provide any input, but I don't even know that will become an issue. That's their choice. It's just making the record clear that CloudBreak, and thank you for that, and Pivot are not present for this. Thank you.
Sounds good, thanks.
So if you could overview here about the exhibits. We're conducting this hearing utilizing electronic pre-filed exhibits as much as practicable. A spreadsheet has been prepared to navigate documents pre-filed in the Commission's administrative record. The spreadsheet has been marked as Hearing Exhibit 1500. It lists the date of the latest filed version of each exhibit as it appears in the Commission's administrative record, a title reference for hearing exhibits that will be utilized during the hearing, and the titles of the hearing exhibit as reflected in the Commission's record. Any exhibit listed in the spreadsheet that is admitted into evidence will be admitted by administrative notice based upon the existing filing referenced in the Commission's file. As such, those portions of the administrative record would become part of the evidentiary record. The fact being administratively noticed is that the electronic pre-filed copy in the administrative record is the content of the otherwise admissible exhibit being admitted. Ms. Frederico emailed the spreadsheet marked as Hearing Exhibit 1500 to you all last week. You have had some time to review it, and with that in mind, is there any objection by any party to the admission of Hearing Exhibit 1500? Ms. Shields.
Good morning, Your Honor. Yes, in the company, what I wanted to clarify is that the company, we have conferred with all parties to this proceeding. I don't think there is any objection to the admission of Hearing Exhibit 1500. Within Hearing Exhibit 1500, I believe that all parties have stipulated to the admission of all pre-filed testimony and attachments. There are several exhibits, however, that the company is not stipulating to that are within that. Those were the pre-filed hearing exhibits of EOC, which are Hearing Exhibit 701 through 709 Revised 1, which I understand they may be moving for admission for today during cross-examination. So subject to that caveat, I believe that all parties have conferred and stipulate to the admission of otherwise all exhibits, as well as 1500.
Okay, so if I've understood you correctly, and I think I did, Hearing Exhibit 1500 and all pre-filed exhibits except for 701 through 709 Revision 1 are stipulated to.
Correct.
Okay, so I will go ahead and admit all of those exhibits as just noted, and EOC during cross-examination, we can get to those 701 through 709 Revision 1.
Wonderful. I understand there are a couple of exhibits from UCA that the parties have also stipulated to.
Okay. Oh, do you know which exhibits those?
I will let Ms. Nelson
Yeah, thank you. Yeah, thank you, Ms. Shields. Your Honor, in UCA's box, there are marked exhibits, hearing exhibit 301 through 305, which all parties have stipulated to. So I would move for the admission of those exhibits as well at this time.
One moment. Give me 1 second here.
Sure.
Okay. So UCA exhibits 301 through 305 are also admitted. So thank you.
Thank you, Your Honor.
Okay, so now moving on to confidential information. We want to keep this hearing as public as possible. I request that we go into confidential session as little as possible or not at all. I'm generally aware of the confidential information at issue in this proceeding, but I do look to public service to let us know before eliciting confidential information so we can adjust our approach as needed. But to the extent you will elicit confidential information, please organize your questions such that we do not need to go back and forth in and out of public and confidential sessions. And on a related note, with regard to the non-disclosure agreements, I have not formally kept track of them, but based on my review, and I could be wrong, I don't believe that either Sunshare or staff have filed any non-disclosure agreements. And that my assessment could be wrong. However, I just want to alert public service that I am entirely relying on you to ensure only people allowed to hear and see confidential information are in any confidential session we may conduct. With regard to the scheduling, this hearing is scheduled for 3 days as needed. Based upon the parties' cross-examination matrix, it does not look like we will need that much time, but I will ask public service, as far as you know, has anything changed with respects to the matrix since it was filed?
No, nothing to our awareness has changed with respect. One preliminary matter that we will be asking of Your Honor is given the comprehensive settlement, the extent to which Your Honor is willing to waive any witnesses at the outset. I think that would be particularly helpful for probably all parties.
Okay.
I'm happy to get there when you're ready.
Yeah, thank you. And we'll get there, I think, pretty soon. So with regard to, now I'll move on to outstanding motions. So on November 17th, the parties filed a non-comprehensive, non-unanimous settlement agreement. And so that is an outstanding motion, which I will rule upon that formally in the recommended decision. But we'll get to a couple what you're addressing, Ms. Shields, in just a moment here. And then on November 21st, Public Service filed a motion for variances and waivers. I do have just a couple of questions about that as it relates to the proposed settlement agreement. And so it looks like paragraph 64 in section O of the settlement agreement says the parties support the waivers and variances motion filed May 12th, 2025. And as the parties know, that motion was denied, and then Public Service filed the new motion November 21st. And so I just want to get some clarification that reference in paragraph 64, is that actually for the November 21st motion? Oh, you are muted, Ms. Shields.
Yes, I think that is a fair assessment and is indicated in the more recently filed motion for waivers and variances. I don't believe that there was any opposition to that, and that motion was built around the settlement, the terms and conditions of the settlement agreement.
Sure. No, and that all makes sense. I just wanted to clarify it on the record, so we're here. And then similarly, Energy Outreach, Colorado, I need to understand when we're talking about the settlement agreement, what you are opposing and what you're not opposing. So I understand from the settlement paperwork that EOC does not join in the settlement agreement, and it appears that this is because of the contested issue related to EOC's recommendations regarding income qualified bill assistance. Does EOC object to any portion of the settlement agreement, and if so, which ones?
Thank you, Your Honor. I also just want to offer that Andrew Bennett has been reserved for cross-examination later in this hearing, and if it'd be helpful to ask him his questions with respect to EOC's position on the settlement, I think that would be beneficial, but I'm happy to also answer it now if you'd prefer.
Well, and we certainly can. I'm happy to ask him, but just to get a sense, I'm trying to sort of get a sense of the scope of the hearing today. And based on the cross-examination matrix, it doesn't appear that EOC is really objecting to the settlement agreement. They just didn't want to join it because of the billing assistance issue, but I want to get clarity on that.
Yeah, happy to. Yep. EOC does object to the settlement agreement based on its failure, is what EOC views as a huge equity gap in the overall settlement agreement based on its failure to incorporate EOC's recommendation regarding energy assistance and based on the failure of the current 2022 to 2025 RE plan.
Okay. Okay, so as it relates to specific provisions within the settlement agreement, it doesn't sound like EOC is going to spend a lot of time arguing specific opposition to specific provisions, more just the large scale objection because of the inequity that EOC believes is within the settlement agreement because of the billing issues or the assistance issues.
I would say that's accurate. Thank you.
Okay. All right. And then, okay, public service. I do have a couple of questions for you, and then we probably could get to your issue that you were asking about a moment ago. I just want can you clarify one thing for me so it's clear on the record? Are the parties recommending that except for EOC, are the parties recommending that the application as amended by the settlement agreement be approved?
Yes,
Okay.
with one caveat, which is there is one outside of EOC's issue with the settlement agreement. The 2020 standard offer is a discrete issue that the settlement agreement does not address. I think the parties have agreed that we are comfortable moving forward in addressing that issue through briefs, and hence why, or through statements of position, and hence why we have been willing to waive cross-examination of all between settling parties. And so that is the one remaining litigated issue outside of EOC's that parties, I believe, intend to address through their statements of position.
Okay, thank you. And then Ms. Cunilio, can you tell me how to pronounce your name again? I apologize.
Yeah, that was actually perfect. So.
Okay.
Cunilio. Yeah, I also just wanted to flag that EOC does plan on asking the company some questions on cross-examination on the 2020 standard offer pricing issue. So just wanted to give you a heads up on that.
Okay, thank you.
And we are prepared to address those.
Okay, wonderful. And then public service. In your statement of position, I do ask for I have one request for you that you might be able to provide a chart that aligns the requests in the application with the provisions of the settlement agreement to the extent that they do align. Does that request make sense?
Could you repeat that one more time? I'm just trying to write it down.
Yeah, of course. It would be great in the statement of position if you could provide a chart of some sort that aligns the provisions in the application as filed on May 12th with the settlement agreement provisions to the extent they align. And I understand there isn't always going to be a one-to-one alignment, but to the extent in the application, if an item X was addressed and then in the settlement paperwork, that item is addressed in section Y, that sort of chart. Does that make sense?
Yeah, it sounds like basically a comparison chart of kind of what I'm hearing, maybe high level core issues and core categories that were or recommendations that were made in our direct case and application, and with parallels as to where or how or if they are addressed in the settlement agreement.
Yes, and this is not intended to cause stress, just something that might be helpful as I go through all of the items, but this is not intended to be a massive project that is intended to like stress you out. Just to the extent you can make something that shows how, if they align, that would be great.
That would be, yes, I think we can do that. Would Your Honor be comfortable to the extent that we could provide that perhaps is an attachment that does not count toward the page limit? Would that be all right? Okay.
Yes. Yeah. Thank you for asking that. Yes, that would be great.
Okay.
Mr. Cox, I see you have your hand raised.
Yeah, thank you. And I just wanted to clarify, I think you mentioned the application, but the settlement agreement actually is an agreement to the company's application as modified by the rebuttal testimony and the settlement. So I just want to make sure that the rebuttal is included in there as well.
Thank you.
And then I just did want to clarify on the non-disclosure agreements. Commission staff is required to do that annually rather than by every case. So we have all staff and council have completed those NDAs.
Great, thank you. I appreciate, I didn't know that, so thank you for clarifying that. And that's why I said I could be wrong, because I'm just pointing out what I saw, but turns out I was wrong. Okay, so it looks like, does any other party have any outstanding issue before we proceed? If so, I could go through everyone one by one, but how about if you do, can you raise your hand? Okay. All right, Mr. Nelson. Or Ms.
That's
Nelson,
okay.
I apologize. Sorry.
No,
Yeah.
that happens all the time. Don't worry about it. No, the only issue I wanted to address was the one that Caitlin or that Ms. Shields already raised concerning whether or not the witnesses that don't have cross-examination designated to them can be excused.
Yes, thank you. I appreciate that. Does any party have any objection to that? I don't mind that, but I do want to see if any party objects to that before I don't see any objection. So yes, thank you for asking that again. Yes, they can be excused.
Thank you, Your Honor.
And then Ms. Vitale, did you have your hand up?
Thank you. I did. I had
Yeah.
the same question that Ms. Nelson asked.
No, thank you. Appreciate that. Yeah. Okay. Thank you, everyone.
I'm sorry, and Your Honor, just to clarify, am I hearing correctly that that means that all witnesses who have no cross-examination scheduled may be excused, including from Your Honor's questions?
One moment. Let me just confer here. One moment. That's okay. Yes, they may be excused, including from questions from me. Thank you.
Wonderful. Thank you.
All right. So it looks like we then are ready to proceed with the evidentiary portion. Public service, go ahead.
All right, Your Honor, with that, I am pleased to bring to the stand Mr. Neil Cowan. I will let you swear him in first, though.
Yeah, sure. Mr. Cowan, can you please raise your right hand? And do you swear or affirm that everything you say is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I will.
Great. And before you proceed, just can you let me know, is anyone with you right now or communicating with you directly as you're testifying?
No.
Okay. If that changes, just let me know and we can go from there. Okay.
I will.
Thank you. Ms. Shields, go ahead.
All right, Mr. Cowan, if you could please state your name and title for the record.
My full name is Robert Neil Cowan. Obviously, I go by Neil. That's spelled Robert Neilcowan. And I am a manager in regulatory administration for Public Service Company of Colorado.
And Mr. Cowan, are you the same Mr. Cowan who filed direct testimony, rebuttal testimony, and settlement testimony along with attachments in this proceeding?
I am.
Okay, and if I were to ask you those same questions today, would your answers be the same?
Yes.
All right, and his testimony and attachments have already been moved into the record. So with that, I'm prepared to make the witness available for cross-examination from Energy Outreach Colorado.
Great, thank you. Please proceed, Energy Outreach Colorado.
Thank you, Your Honor. Good morning, Mr. Cowan.
Good morning.
My name is Casey Canelio for the record, and I'm the attorney representing Energy Outreach Colorado, which I'll shorten to EOC. We have met before, and it's nice to see you this morning.
Nice to meet you as well.
And I just want to note for everyone that I have 120 minutes or 2 hours reserved for Mr. Cowan. I also have 20 minutes reserved for company witness Patrick Murphy. And so to the extent I need to borrow some time from that 20 minutes of Mr. Murphy, I will let you know. But Mr. Cowan, some of the questions that I might ask you, might want to defer to your colleagues. So just wanted to let you know that we have that option.
Very good.
So I'd like to walk through several topics today with you, including the company's performance under the income qualified or IQ community solar garden or CSG programs, the resulting impacts on IQ customers, the company's views on rollover capacity under the pending settlement agreement, the company's response to EOC's IQ energy assistance proposal, and the company's standard offer pricing error. So let's start with some foundation questions just to level set. You are Public Service Company's lead witness sponsoring testimony for the 2026 to 2027 RE plan, correct?
I am the lead policy witness, and I did sponsor the testimony summarizing the settlement agreement.
And you sponsor testimony on IQ and disproportionately impacted or DI customer programming in this new plan, correct?
I cover it at a high level. More specific programming questions would be pointed towards my colleague, Mr. Murphy.
Okay, thank you. And you also sponsored the company's testimony describing the new plan and its relationship to the prior plan. Is that correct?
I do so at a high level, yes.
Thank you. And you were a witness for the company in the prior 2022 to 2025 RE plan proceeding number 21A-0625EG.
I was, however, in that role, I took on mostly voluntary programming like Renewable Connect, Wind Source, which became Renewable Connect Flex. So I also sponsored Renewable Connect Natural Gas that never came to be. So I was that was my role, was more specific programming, if you will.
Okay, but you're generally familiar with the prior proceeding?
I am generally familiar with it, yes.
Okay. And your rebuttal testimony in this case provides the company's rationale for rejecting EOC's IQ bill assistance recommendation.
Yes.
Okay, thank you. If we could please pull up what's already been admitted is UCA attachment SEE10. That's a part of hearing exhibit 300.
Sorry, my computer froze. Give me just a second.
No worries. Well, maybe while that's getting set up, Mr. Cowan, are you aware the commission approved the 2022 to 2025 RE plan through decision C22-0678, adopting the settlement in that case? Does that sound correct?
That sounds correct, yes.
Okay, great. And if we could turn to page 11 once we get this pulled up, perfect. So under the, Mr. Cowan, under this approved settlement, the commission authorized 3 income qualified community solar components. So if we could actually scroll down a little bit so we can see paragraphs 32 a little bit clearer. The commission authorized 3 income qualified community solar components: the IQ standard offer, the IQ portion of the CSG RFP program, and the company owned gardens. Does that sound accurate?
Correct. And I would also note that I believe this decision was rendered around November of 2022, if my memory serves me.
Thank you. And just generally speaking, community solar programs provide solar access for customers who cannot or are not or do not want to install on-site solar on their homes. Does that sound accurate?
Generally, yes.
Okay, great. If we could now on this decision turn to page 23 and go to the end of paragraph 65. Okay, great. Mr. Cowan, do you see here in the commission's decision that each of these IQ community solar components was intended to provide bill credit benefits to income qualified and DI households?
Yes, and I would add some other data points. The RFP for this particular program, well, it was for the standard and the IQ side of the CSG program that launched in 2023. And then the standard offers, I believe, were opened up in 2024. A few data points there in terms of chronology that I think are important to note.
Okay, thank you. And so just to confirm, these IQ community solar programs were approved by the commission for the 2022 to 2025 plan period, correct?
Yeah, for that plan, correct.
And the intent of approving this IQ dedicated community solar capacity in the 2022 to 2025 plan was for those projects to be constructed as a result of the plan, correct?
It's to make available capacity. I don't think in decisions it indicates that, all this capacity will be constructed. I think it's the company will make it available. And, there are many other variables at play that are involved in a successful interconnection of a CSG. So I think that context kind of matters.
Okay.
But they approved that capacity to be allocated out. It was not thou shalt construct this amount.
Understood. So, but when the commission approved the associated budget for this past plan, that was with the understanding that not only would the capacity be made available, but the projects would be constructed.
I think there's an expectation, but it's more like leaning towards it's made available. This is the estimated budget impact.
Okay. So the incentives and bill credits budgeted for these IQ community solar programs, those could only be paid once gardens became operational and produced energy. Does that sound accurate?
Yeah, largely that's, I can't speak for any other subscription type of discount because subscriptions are handled by the garden owner or developer. I can only speak to the company issues bill credits, which I would assume takes care of some, perhaps all of the discount that is being sought by a IQ subscriber.
Thank you. So just to summarize, this decision that we've got pulled up here approved the IQ standard offer, the IQ RFP capacity, and the 20 megawatts of company-owned gardens in order to deliver community solar bill credits to income qualified and DI customers as a part of the 2022 to 2025 plan.
Generally, yes.
Okay, thank you. We could take this exhibit down, and if we could actually now pull up EOC hearing exhibit 711, that's in EOC's box folder. And while that's getting pulled up, Mr. Cowan, I'll ask you, do you recall being asked in discovery to provide the total, the percentage of the total 2022 to 2025 RE plan capacity that is currently interconnected and operational?
Yeah, can I review this discovery response?
Yeah, maybe we can scroll down a little. Yeah.
I can make it bigger if needed too. Just let me know.
That's adequate. Thank you. Yes.
And you were the sponsor of this discovery response, EOC 16.
As it says there, yes, I did sponsor it.
Okay, great. And we'll get into the supporting attachment in just a minute, but for now, I'd like to move for the admission of EOC hearing exhibit 711.
Ms. Cornelia, are you moving for the admission of the attachment as well?
I'll be doing that right after this. I just thought it made sense to do them separately, but I can do them together once we go over the attachment if you'd prefer, Ms. Shields.
Yeah, I would prefer if we could lay the foundation for both of them at the same time and move them in. However, I'm not objecting to necessarily asking questioning around the document in front of Mr. Cowan, but I want to make sure that we have the foundation for the attachment.
If we can now turn to hearing exhibit 704. This was a part of hearing exhibit 1500, but was not stipulated earlier this morning for its admission. And while this is getting pulled up, Mr. Cowan, the company produced the attachment EOC 16A1 in response to EOC 16, which we just had pulled up on the screen. Is that correct?
Correct.
And as part of this attachment, it reflects the company's own track progress of each IQ dedicated. In part, it reflects each IQ dedicated community solar program in the 2022 to 2025 plan as of the date of the discovery response to EOC 16, which was November 19th, 2025. Does that sound accurate?
Yeah, and I think the date of this does matter. I forget what it is, as of October or November, I believe, of 2025. I can't remember exactly. I mean, it's relatively recently. And you phrased your question in terms of the company's success, or the company's results. I mean, this is the results of the program. The company administers the program. We make available capacity. We help with interconnection. I don't know if I fully agree with that characterization that this is essentially the company's full responsibility. This is what the program has yielded thus far to that point in time, and doesn't reflect. And another thing I will add too, and this is perhaps something for Mr. Murphy to get into detail. It doesn't reflect gardens in their various stages of development. So, I mean, this is answering this question, this discovery response directly. It's taking a moment in time and interconnection. It doesn't reflect where they are in the study process, if they're close to seeking IA. Those are details that I think Mr. Murphy should address.
Okay, thank you.
Yeah.
Sorry, didn't mean to cut you off.
Yeah. No, I think some of that context around this does matter to the overall situation. So what you have here is, as of a recent date, which ones are interconnected. Okay,
thank you. And hopefully, with all of that foundation, I can now move for the hearing exhibit, or for the admission of hearing exhibits 711 and 704.
No objection.
Okay, hearing exhibit 704 and 711 are admitted.
Thank you. And so now, Mr. Cowan, if we can maybe zoom in a little bit to the, so we can see this table a little bit better. So according to this table on the screen here, the company has interconnected 0 megawatts of the IQ and DI standard offer capacity approved in the 2022 to 2025 plan. Is that accurate?
Can you restate that again? Sorry.
Sure. So according to the table here, the company has interconnected 0 megawatts of the IQ and DI standard offer capacity approved in the current RE plan.
That's what this reflects. And again, I'll point to my colleague, Mr. Murphy, will have details of where projects really are in their development, which I think is important. And I also referenced my earlier statement about how this program has as it's been laid out or issued over time. So I think those are that's another data point, or couple data points to reference as well.
Okay, understood. And the company has interconnected 0 megawatts of the 20 approved megawatts of the company owned IQ CSGs, correct?
From that res plan, yes, we are in the midst of working to interconnect. We are in construction of the 8 megawatts from the 2020-21 plan.
Great, and we'll get there. Oh, sorry, we'll get there later this morning. So I appreciate that. And so as of today, the company has also interconnected. I apologize. I don't know. I asked you about the company owned and I think the IQ DI standard offer. I did not ask. the company has not interconnected any megawatts of the IQ-DI SRC RFP capacity improved in this current plan, correct?
Yes, I mean, safe
Okay.
to say, the zeros are, explained that for the SRC program, the IQ component of it, zero amount of that has been interconnected. Again, but I would also point back to Mr. Murphy has the details of where projects are in their various stages of development.
Thank you. So as of today, the company has interconnected 0 megawatts of the IQ CSG capacity that's been approved in the 2022 to 2025 plan.
Thus far.
Okay, great. If we can now please go to hearing exhibit 713 in EOC's box, and I will just represent that this is a demonstrative exhibit, Your Honor. And so I have it labeled, but I may not necessarily move it for admission, but it's a demonstrative exhibit created from this table, hearing exhibit 704. So Mr. Murphy, Mr. Cowan, according to what we just went over in this table in the hearing exhibit, so just 3 megawatts out of 165 megawatts of the approved capacity that is 100% dedicated to IQ and DI customers. Those 3 megawatts just represent 2% of the total approved capacity in this plan. Does that sound accurate?
Sorry, objection. I haven't seen this exhibit, and I'd just like to make sure we have sufficient foundation laid for Mr. Cowan. I don't know that necessarily the numbers in here total with the discovery response that we had seen, so I'd request more foundation.
Sure. I guess if we could pivot back to hearing exhibit 704, which is the table. So Mr. Cowan, out of the 6 programs that are 100% dedicated to IQ and DI customers, we've got the Solar Rewards IQ on site managed by the Colorado Energy Office, the Solar Rewards IQ DI community on site, and then we've got the RBC Renewable Battery Connect program, the RFP IQ DIC and the standard offer IQ DIC and the company owned garden. So the capacity included in the settlement agreement of those 6 programs, would you agree with me that totals 165 megawatts of approved capacity?
Subject to doing my own math on it, which I get really nervous when I have to do math in front of people. So I'll take your word for it. I will also point out that that's thus far, and our on-site programming has seemed to do better than the solar gardens in this department. But then again, this is a snapshot in time. These projects, there are projects in various stages of construction. So it's the issue I have with this, in answering this, is it kind of puts it in a vacuum. And there's a lot of context around it. Like there's projects, CSG projects can take, many months, if not a couple of years to develop. So it's again, this kind of puts it in a vacuum, like, oh, as of today, these are 0, which is, true today, but we could have an interconnection, later this month. We can have interconnections, happen in January, February. So this is just a moment in time. It's a bit of a vacuum.
Okay. If we could turn back to the demonstrative exhibit. Hearing exhibit 713. Right? Yeah. So, and just for Ms. Shields, I'll just say we just went over the 165 megawatts of the approved capacity, and then based on the table that the company provided as of November 19th, 2025, the 3 megawatts that have been interconnected in some of those programs is what creates this visual. So Mr. Cowan, we're at the end of this plan period for the current RE plan. Is that accurate to state?
We are, but again, we have projects that can reach IA. Well, in fact, with the rollover, unallocated capacity will become ICS, which has its IQ component to it. So that capacity, shouldn't be characterized as lost. It will continue on. So, I mean, as of 12th, December 3rd today, this is a fair representation of where we are, but there can be more projects interconnected. There's a possibility there.
Okay, thank you. We can take this demonstrative exhibit down, and I don't need to move for its admission. So Mr. Cowan, in this proceeding, do you recall that the joint solar parties, COSA, SIA, and CCSA testified that developers have not stepped up to build IQ and DI standard offer projects under the company's current RE plan?
Sorry, can you state that again?
Sure. Wait, let's just pull up, if we could, hearing exhibit 1101 and go to page 77.
Sorry, quick comment. I was more looking like who has the testimony.
Yeah, so if we could, starting at line, yes, this is great. So Mr. Cowan, is proceeding, do you recall that the joint solar parties testified that developers have not stepped up to build IQ and DI standard offer projects under the company's current RE plan?
Coming from, well, some of this testimony I definitely disagree with.
That's not what I'm asking. I'm asking, do you recall that they testified to this?
Yeah, I'm looking at where on this page that specific reference is, and the line 3 catches my eye, and I don't agree with it. Sorry. Can you direct me to a specific passage?
So I'd also object on, I mean, this is not Mr. Cowan's testimony. I mean, I'd object on hearsay grounds. I'm not really, at this point, it sounds like he's being asked questions to assert the truth of the matter in someone else's testimony.
I appreciate what you're saying. To me, it sounds at this moment that Ms. Cornelio is just asking if he recalls this. And I'm going to go ahead and allow it because I am not so far taking it as hearsay, but I appreciate the concern. And if it comes up again, of course, go ahead and make another objection.
Thank you, Your Honor.
So Mr. Cowan, yes, I did ask if you recalled this testimony, and if you see on line 1, the joint solar parties, the question asks why no developers stepped up to offer IQ and DI projects through the standard offer. Do you see that on lines 1 and 2?
I see that lines 1 and 2. I disagree with the answer.
Okay. And do you see, if we could scroll down actually to I apologize. Okay, so sorry, just line 3, so not that far down. But do you see here that one of the joint solar parties witnesses testified that the company's poor management of the 2022 to 2025 RE plan resulted in Solar Award's community standard offer not being released until very late in the 4-year plan cycle?
Yeah, and I very strongly disagree with that statement. In fact, Mr. Felder, I didn't even know he was associated with, I believe, CCSA. He was not part of any discussions rolling out the RFP. He was part of no discussions to allocate capacity for the standard offer. So I flat out disagree with that characterization. I know that again, and I pointed to some dates. When the decision in the case took place, when the solicitation happened in 2023, working with the developers and COSA and CCSA to come up with a plan to allocate capacity so we wouldn't get overflooded studies for our engineers, and then having to work with them again to change that into an open interconnection queue that we had to implement and operationalize by August of 2024. So to hang this on the company, I believe, is unfair and not justified. But it also points out that this program came out in various stages over time, and it didn't all happen 1/1 of 2022 at the absolute possible beginning of this plan. It didn't happen. So,
okay.
But I disagree. I flat out disagree with that statement.
Okay, and you actually did address this testimony in your rebuttal testimony. Does that sound accurate?
I believe so, yes.
Let's pull it up, hearing exhibit 107, and go to page 30. And so, Mr. Cowan, do you see here that on lines 10 to 13, you acknowledge that the company had to develop an updated interconnection study process, which did take time to develop? Is that correct?
Yes, and we worked collaboratively with COSA and CCSA, and again, for them to make that statement, I believe is it's not right.
Okay. If we could actually now turn to hearing exhibit 705, which is the company's 2024 res compliance filing, and go to page 17.
705 revision 1, right?
Correct. Yes. Page 17, please. So Mr. Khan, do you see here how the company reported, and you alluded to this earlier, throughout 2024, the company continued to develop the incremental 8 megawatts of company-owned community solar gardens approved in the 2020 to 2021 res plan?
Yes.
And those 8 megawatts are from the prior 2020 to 2021 res plan and are not in reference to the 20 megawatts of IQ dedicated capacity CSGs approved in the current 2022 to 2025 plan, correct?
Yeah, they are different capacity allotments.
And this same page also reports that the company has 6 megawatts of existing company-owned IQ CSG gardens that are already operational and providing bill credits to IQ subscribers, correct?
Correct.
Okay, great. I would like to move for the admission of hearing exhibit 705. It's already in the commission's files, so it could be moved through administrative notice.
Yes, and Ms. Keneally, just to confirm, this is a full copy. I see 95 pages, so I am assuming and take your word that this is a complete copy of the res compliance report.
Correct, yes.
Thank you. No objection.
Okay, so just to make sure I have it correct, hearing exhibit 705 revision 1, that correct?
Yes.
Okay, yes, that is admitted. Thank you.
Thank you. So Mr. Cowan, is it fair to say that in the 2024 calendar year, the company continued developing IQ dedicated community solar gardens from the prior plan and continued providing bill credits under the existing 6 megawatts, but none of that development pertained to the 20 megawatts of IQ dedicated company-owned gardens approved in the current 2022 to 2025 plan?
Correct. And I one of my prior answers to one of your questions, I elaborated. Our focus is on trying to complete those 8 megawatts before we turn to the 20 megawatts.
Okay. So is it fair to say that the IQ dedicated community solar capacity that the commission approved specifically for the 2022 to 2025 plan, the IQ standard offer, the IQ portions of the RFP, and the 20 megawatts of company-owned gardens have currently delivered 0 CSG capacity during the current plan period?
I'd say to date, yes.
Okay, thank you. And we can take this hearing exhibit down. So Mr. Cowan, if a community solar garden never interconnects, then there would be no subscribers and therefore no bill credits. Would you agree with that?
Yeah, yes, and I would add that not all program capacity, be it on-site, be it CSGs, just because it's approved in a plan doesn't mean that that's going to get interconnected. So.
Okay. And without bill credits, customers receive no bill savings from those specific offerings, right?
And again, from the bill credit savings, yeah, I can't, again, speak to any sort of other arrangements they may have with a garden operator or developer.
Okay. And based on the company's own progress reports we just discussed, the IQ dedicated community solar programs approved in the current plan have not produced any bill credits for IQ customers during the plan period, correct?
During the 22 through 25 plan period, not yet, no.
Okay. And if we could please pull up hearing exhibit 712 in EOC's box folder. And while this is getting pulled up, Mr. Cowan, do you recall that when public service was asked in discovery to produce any analyses quantifying bill credit value or other benefits currently delivered to IQ customers or IQ customers under the 2022 to 2025 RE plan? And we might need to scroll down a little on this.
Yeah, this appears to be the same discovery response that you put up before, correct?
Different.
Yeah,
This is a different discovery response. So in this question, the EOC asked the company to produce any analyses quantifying the total bill credit value or other monetary benefits currently being delivered to IQ customers in the 2022 to 2025 RE plan. Do you see that in subpart 1 of the question?
yeah.
Or A?
I do, yeah, and I do note our objection there on some of the terminology used. So, yes,
Okay.
I'm aware of this. Yes, sorry, it took me a little moment to review it. Yes, I'm
I'm sure
aware
you
of
got
this.
served a lot of discovery in this case. So the company's answer in subpart A to this request was the company does not have the requested analyses, correct?
Yeah, I mean, based on the objection, we didn't fully understand the question, but I mean, we don't have an analysis. I don't think we do have an analysis that addresses this question.
Okay. And you're the sponsored witness for this response, correct?
Yes.
I'd like to move in to admission hearing exhibit 712 into admission.
No objection.
Okay, hearing exhibit 712 is admitted. Thank you.
Thank you. If we can now turn to hearing exhibit 701. It might be a Rev 1, it might not be. And Mr. Cowan, this is EOC supplemental response to public service 2-1. And I'll just represent that I plan on admitting this through Mr. Bennett once he's on the stand later today. But Mr. Cowan, do you see here in this discovery response, Mr. Bennett states that according to, oh, sorry, can we actually scroll down to, I think, the second page? And actually, we're going to keep going down because it's the supplemental part of the response. I apologize.
What page?
Page 3, I believe. Okay, great. Thank you so much. Mr. Cowan, do you see here in this discovery response, Mr. Bennett states that according to EOC's program data, an IQ subscriber and an EOC administered CSG receives an average monthly bill credit of about $60?
That's what he says. I have no basis to understand. I have to take his word for it, but I don't know what these numbers fully represent. That chart kind of confuses me a little bit, to be honest with you.
Yeah, and objection to this document on grounds of hearsay and no foundation. It's a document that Mr. Cowan has, he's not the sponsor of, and did not write, and I think just indicated that he's not aware of the data in this document.
My understanding was that Ms. Cornelia was going to move to admit this with Mr. Bennett, so I will allow the questioning related to this for now, but if it continues without a resolution of the issues here pretty quickly, then we may need to stop it, but go ahead.
Okay. Ms. Crown, I can also speak in hypotheticals if that's helpful too, but so hypothetically, if an IQ CSG subscriber receives about $60 per month in their CSG bill credits, that translates to roughly $720 per year in bill savings. Would you agree? And sorry to make you do math.
Again, I will, that's what this says.
And you see,
Ms. Cornelia, I'm sorry for the interruption. This is the court reporter. If you could please slow down.
Sure. I apologize. I have a lot to get through. So I will go slower though. I apologize. Mr. Cowan, do you see here in this discovery response that there's more than 9,000 income qualified customers on EOC's community solar waitlist as of late October 2025?
Again, that's what's said here. I have no means of verifying that or understanding that number, but that's what it says.
Okay. Assuming that's accurate, would you agree that these waitlisted IQ customers would be eligible for community solar bill credits had some more IQ dedicated CSG capacity approved for the current plan come online?
Renew my objection on hearsay grounds. And I mean, there is no foundation with this witness. He has already indicated that he is not familiar with these numbers and cannot verify the data and information that's contained in this document.
I'm going to overrule the objection. So go ahead and proceed, Mr. Cowan.
Can you restate the question?
Yeah, so the 9,000 waitlisted IQ customers, these customers would have been eligible for community solar bill credit benefits had some of the IQ dedicated CSG capacity approved for the current plan come online.
Up to that point,
Correct.
yes. I mean, I would also add to this that, again, capacity is, as of that point, yes, but capacity is in various stages of construction. There's a rollover to consider in this settlement agreement. So to simply say that like they're out this opportunity, I don't think is completely accurate. There's opportunity in the future.
Okay.
So,
do you also see in this hearing exhibit that EOC has quantified that these customers carry a collective $3 million in past due arrearages on their Excel utility accounts?
that's what it says. I don't specifically deal in arrearages, so I have to take this response as that's what it says.
Okay. Would you generally agree that for IQ customers, it is common for these households to experience reoccurring or persistent energy affordability challenges?
While I do touch on IQ programming, that's accurately say I touch on IQ programming. I don't go into extensive detail on energy assistance. So I don't know if I can answer that question.
Okay. Would you agree that bill credits reduce a customer's utility bill?
Yeah, they have the possibility of reducing, yes.
And reducing a bill could also reduce that customer's arrearages, potential future arrearages.
But hypothetically speaking, potentially along with other forms of assistance that could be utilized as well.
Okay, thank you. And last part of this discovery response, before we can take it down, EOC also estimates that had adequate IQ dedicated CSGs been built, the total annual bill savings available to these IQ customers on the wait list would have exceeded $6.5 million a year. Do you see that?
That's EOC's analysis.
Okay, great. And we can take this hearing exhibit down, and as I said, I'll move it for admission later in the hearing. Mr. Cowan, in your direct testimony, you state that IQ customers are the group who needs the greatest support, correct?
Can you direct me to that specific reference in my testimony?
Yes. Let's go to, please, hearing exhibit 101, top of page 4. And I think I don't have the right page number. Hold on, sorry, one second, Mr. Cowan. It might be the top of page 3. Could we look there, please? I apologize. Oh, sorry. It is actually the top of page 4, 5 lines down. I apologize. So Mr. Cowan, do you see here that the company made certain modifications to the new plan to drive participation among IQ customers who you say need the greatest support?
Yeah, I mean, and I think contextually around this, it's it's a variety of programming too. So was your question, if you're asking specifically about CSG program, that's one of the variety of programs that do help these customers. Excuse me.
Thank you. We can take Mr. Cowan's direct testimony down. Thank you. So Mr. Cowan, we previously went over how the commission approved 20 megawatts of company-owned CSGs dedicated exclusively to income qualified customers as a part of the 2022 to 2025 RE plan, correct?
Correct.
And those 20 megawatts are intended to deliver community solar benefits directly to IQ households. Is that accurate?
Yeah, that is correct.
Okay, great. If we could go to hearing exhibit 710 in EOC's box. And this is gonna, Mr. Cowan, this is gonna be the settlement agreement for the current plan. And if we could actually go to the last page, because the settlement agreement includes attachment A that was filed with this settlement agreement. So Mr. Cowan, can you confirm that this, in this attachment, the company estimated that the 20 megawatts of the company-owned IQ Gardens would deliver approximately $52 million in bill credits over 20 years?
Yeah, sorry, this is really small and I want to make sure I'm responding correctly. Can you make this bigger, please?
I can, but I won't be able to fit the whole table. So which part should we zoom in on?
The company-owned gardens under solar rewards capacity. So it's the middle, kind of the middle table.
Which I believe is the bottom section of the, okay.
Yeah, how's that? Or do you need it one more bigger?
No, it's fine. Yeah, company offered. Okay, yes.
Okay, so you'd agree that in this attachment, the company estimated that $52 million in bill credits over a 20-year period.
Yeah, that's an estimate over 20 years.
Okay, great. And so, sorry to make you do math again, but dividing that $52 million over 20 years, that results in roughly $2.6 million per year in IQ customer bill credit value. Does that sound accurate?
Sounds about right.
Okay, thank you. And we went over in the company's ROS compliance filing that was filed earlier this year and you testified the company is still developing the 8 megawatts of company-owned IQ Gardens approved in the 2020 to 2021 ROS plan, correct?
Yes.
And so that means, and you said this, but just confirm, you said, these gardens take multiple years to progress, correct?
Yeah, I think if you look at this table and say, oh, well, I expect 5 megawatts to be developed, this year, and this year, it might be a little bit misleading in terms of the timing of this. So that's based on a capacity, that's based, the overall capacity and the estimated bill credits, based on that amount of capacity.
Okay. And
so
we've established,
sorry, I want to add to my answer. This is the allocated capacity for the plan. It's not the anticipated interconnection timing of that capacity. So I think some of your questioning makes me think this is expected by the end of 2025. And I would say that's probably, it's not realistic. Because these projects do require a long lead time. Again, my colleague, Mr. Murphy, can go into detail on status of a variety of vintages of CSG projects from prior plans, the 22 to 25 plan, to add a bit more color to this.
Okay, thank you. And so we've established that the company has not interconnected the 20 megawatts of company-owned gardens during this plan period so far. So does that mean that $2.6 million per year in projected bill credit value has not been delivered to IQ customers during the 2022 to 2025 plan?
Based on those assumptions, it has not, because that capacity has not been interconnected.
Okay.
Yeah.
And we can take this exhibit down. Okay, so Mr. Cowan, in your direct and rebuttal testimony, you do not, and settlement testimony, you don't propose any compensation or bill credit remedy for IQ customers for missing benefits from the unbuilt capacity of the IQ dedicated gardens. Is that accurate?
I do not. And to add to that, I would say that it's kind of a matter of perspective. If the perspective is that all that capacity would have been interconnected by the end of 2025, I think there's a lot of recalibration of expectations that go all the way back to the previous, the settlement in the 22 through 25 plan.
Okay. If we can now turn to the settlement agreement that's been filed in this case and marked as hearing exhibit 113. And at the bottom of page 3 and into page 4, I'd like to turn to. And Mr. Crown, you might be able to answer this without the document being pulled up. But approximately 206 megawatts of unbuilt third-party solar rewards community capacity rolls into next plan as proposed under the settlement agreement, correct?
Yes, and that 206 megawatts will be further refined by the end of this month to determine, what that exact amount is. But as of the settlement agreement, that was 206 megawatts.
Okay. But the settlement does not roll over the 20 megawatts of company-owned IQ capacity. Is that accurate?
That was not specifically included in the rollover amount. That was for the standard offer. And I believe the everything else besides the company owns. Let's put it that way.
Okay, thank you. And so you've mentioned the company hasn't begun construction on any part of those 20 megawatts, correct? Of company-owned gardens.
Today, no.
And you might want to defer, or you might defer to Mr. Murphy. I'm happy to ask him, but does the company currently intend to build any portion of the 20 megawatts of company-owned IQ CSGs approved in the current plan?
And perhaps he can add color. I do know that the focus, and I mentioned this earlier, the focus has been on trying to complete the 8 megawatts from the previous plan. So that's where our focus and attention has been. So the 20 megawatts from the 22 through 25 plan will be looked at next.
Okay, so they're kind of on the back burner right now?
I don't know if I can. It's just not we're trying to complete the 8 megawatts. I don't know if I agree with that characterization, but.
Okay. So just so we're clear, the commission approved 20 megawatts of company-owned IQ community solar, which represents more than 50 million in projected long-term bill credit value to IQ customers, has delivered 0 bill credit benefits to IQ customers so far, correct?
To date, yes.
Okay, great. And we can take this exhibit down. Thank you. So Mr. Cowan, throughout the current plan period, the company has collected RISA funds at the 1% level, correct?
Yes.
And we've covered earlier that the company has interconnected 0 megawatts of IQ community solar capacity that's been approved in the 2022 to 2025 plan, correct?
Interconnected, but again, I've pointed numerous times back to Mr. Murphy. There are many projects in various stages of construction from the 22 through 25 plan. Not to mention there are previous vintages of solar gardens that are also still in various stages of construction and development too. So again, isolating these down is a little bit problematic for me, but.
So none of the current plans, IQ CSG programs funded through the RISA have delivered any customer bill credits, correct?
To date, yes, but that doesn't prohibit them from being projects in the future. Again, okay. I don't know if I agree, like from this point, yeah, that number's, that's correct, but there's contextual information out there that says there are projects out there that are in various stages. So to simply say this will never happen is incorrect.
Okay, but my question was just, as of right now, none of these projects have delivered any bill credits to customers, right?
Yeah, but there's opportunity. I see opportunity in the future, but to date, no.
Okay. And so in your direct testimony, we don't necessarily need to pull it up, but you know that the RISA currently has an overcollected balance or surplus of approximately $150 million. Is that accurate?
Correct.
And one of the reasons for that overcollection is that actual spending on RISA funded programs, including IQ community solar programs, has been far below budget. Is that accurate?
Can you restate that question? I don't know.
Sure. Is one of the reasons for the RISA overcollection of 150 million because as the result of this company's spending on RISA funded programs, including the IQ community solar programs, being below budget?
It'd be part of it, but I mean, there's a lot of different resources that utilize the RISA So a portion of, yes, do I know how, to what extent? I don't have that calculation.
That's fair. And I didn't reserve any time for your RISA expert colleague, so we won't go there. So IQ customers have paid into the RISA for 3 years under this current plan, but none of the IQ community solar capacity approved for this current plan has come online. And IQ customers have received none of the community solar bill credit benefits that were planned for them in this RE plan. Is that accurate?
Yeah, again, taking this in a vacuum for this plan, yes, but I mean, there's previous vintages of CSGs with IQ commitments. There's other IQ programming that takes advantage of the RISA. And broadly speaking, the greening of the system that we've utilized the RISA for many years, everyone has been paying into that, and everyone's been benefiting. So I think a lot of contextual information around that's necessary to fully understand benefits received. So
got it. Thank you. Mr. Cowan, the Inclusive Community Solar or ICS program, that does not begin until 2026, correct?
Correct.
And so ICS does not make up for the community solar benefits that were supposed to occur during the 2022 to 2025 plan, correct?
I don't know if I'd say it entirely. I mean, we're rolling forward capacity. We have a very pretty healthy interconnection queue of projects. So I don't know if I totally agree with that.
Okay. ICS provides a minimum of 25% bill savings for IQ customers. Does that sound accurate?
I believe so, yes.
And the higher ICS savings tiers, 30%, 50%, and 55%, require project developers to qualify their projects for federal IRA tax credits. Does that sound accurate?
That sounds accurate.
All right, I'm going to try to keep this high level. So on the ICS. So to receive those IRA tax credits, projects must interconnect within specific federal timelines, correct?
I believe that's correct, yes.
Okay. And if we could turn to attachment A of hearing exhibit 113, the settlement agreement. And so, Mr. Cowan, once it gets pulled up, this shows that under the settlement, 206 megawatts of unbuilt Solar Rewards community capacity will roll over into 2026, correct?
That's what we agreed to, yes.
And attachment A also shows that 100 megawatts of ICS capacity is planned for 2026, correct?
Yes, and that 100 megawatts is bringing forward that capacity from 2027. We were statutory required to make available 50 in 2026 and 50 in 2027. So that 100 represents a bring forward of capacity, which coupled with our open interconnection queue, I'd say we're positioned to take advantage of the current situation as much as possible. I think that's one of the benefits of this settlement agreement, of this plan, is we're trying to do that. So we're trying to work within the parameters that we know of today.
Okay. So in 2026, the company will attempt to bring 306 megawatts of ICS in a single year or two to meet federal tax credit eligibility windows, right?
We're making it available. I mean, that's there's a lot of steps, to projects. So we're making it available.
Okay.
So if we have, just to add some practicality to it, if we have projects that are in an advanced state of their interconnection, they can take that capacity quickly. If they take longer, it'll be a little bit longer, but we're making it available for developers.
Okay. Would you agree that the 306 megawatts represents far more community solar capacity that came online during the entirety of the 2022 to 2025 plan period?
Yeah.
Thank you. In your colleague, Mr. Murphy's rebuttal testimony, he discusses some of the parties' concerns that developers need to bring capacity online quickly to qualify for IRA tax credits, correct?
Correct.
And given the need to interconnect approximately 300 megawatts in a short time frame, timely interconnection may become difficult, correct?
I'm speculating. I mean, we're doing what we can to make it available. So, I mean, it might be, yeah, there's probably challenges out, certainly there's challenges out there. I would not, to say there are none, I'd say that's incorrect, but there are definitely challenges out there.
And interconnection delays may make it harder for projects to qualify for the higher IRA tax credits, correct?
And it might, but interconnection delays might, there's a lot to that, because interconnection, not only are, they're studying the projects to make sure they're safe, to ensure safety and reliability to the grid, which is of utmost importance, but there's also land acquisition, there's permitting with the local authorities, there's supply chain issues potentially, and I'm sure there's some other variables that I haven't thought of, here and now. But so when you say interconnection, I think there's a lot to interconnection. There's a lot of variables.
So in practical terms, given the federal deadlines and the amount of capacity that must interconnect, most ICS participants are likely to receive the minimum 25% savings tier, correct?
I think that's me speculating. I don't know.
Okay.
I feel I've helped with the development of the 6 megawatts of the company owned gardens, and a little bit with the 8 megawatts. But I wouldn't characterize myself as a solar garden developer.
Okay. We could take this down. Thank you, Mr. Khan. The commission approved the 2022 to 2025 RE plan through a decision, through the decision that we had pulled up earlier, correct?
876, I believe it ends with, correct? Yes.
Yes, good job. And the settlement agreement governs the company's community solar programs for the 2022 to 2025 plan period, correct?
Yes, with the exception of we are, bringing forward capacity. We're bridging 2 plans now with that rollover.
Got
So
it.
No, my point's made. We're bridging 2 plans. So, I mean, if you're thinking that there's a steep cliff here and then a rise up, there's actually a bridge over between the 2 plans. At least that's the way I see it.
Thank you for that visual. If we could pull up hearing exhibit 710, we had it previously pulled up, but it's the settlement agreement for the current RE plan that's in place. And Mr. Cowan, I'm not sure if I asked you this earlier, but are you familiar with the settlement agreement? You were a witness in this.
Yes.
In this case, not the lead witness, but a witness nonetheless. So if you could go to page 18 of the settlement agreement. So Mr. Cowan, do you see here that there's a paragraph 36 of the settlement agreement?
Yes.
And paragraph 36 addresses donated community solar subscriptions, correct?
Yes.
And paragraph 36 specifically refers to these donated community solar subscriptions as a form of energy assistance, correct?
That's what it says.
Okay, great. I'd like to move for the admission of hearing exhibit 710 through administrative notice.
Yes, and no objection from the company, though I'd reserve my right to object to lines of question that may be outside the scope of Mr. Cowan's expertise or knowledge, but no objection to moving this into the record.
And it can be admitted. I don't necessarily think it needs to be admitted as evidence, but I have no issue with admitting it so go ahead and proceed.
Just to be safe. Thank you. So Mr. Cowan, those donated CSG subscriptions contemplated in the settlement are delivered through the Solar Rewards Community Program, correct?
Yes.
And those solar rewards, community incentives, and bill credits are funded through the RESA, correct?
Bill credits are funded through the RESA.
So under this commission approved settlement, these RESA supported SRC subscriptions donated to IQ customers were classified as energy assistance, correct?
I think technically it's a form of. I think that a form of it matters in this context.
Okay. But in your rebuttal testimony in this case, you state that using RESA for energy assistance would likely not be possible, correct? And we can pull it up if that's helpful.
Yeah, and I'll first state that I'm not a lawyer, but I think using the RESA, RESA is used for eligible energy resources, renewable resources, and the programming associated with those. I don't see the RESA being able to be for strictly energy assistance payments. That's my understanding of the RESA and what it can be used for. So it can be used for the administration of programming. It can be used, for the bill credits, because those are it's tied to resources that are covered by the RESA. So if you're saying the RESA can be used for energy assistance, I in line with my rebuttal, I can't agree with that.
Okay. We can actually pull up your rebuttal testimony, which is hearing exhibit 107, and go to page 32. And starting at line 10. Oh, wait, sorry, 32. Apologize. Thank you. So just to clarify this, in your rebuttal testimony, on line 10 here, you state that using RESA for energy assistance would likely not be possible, correct?
Right.
And your rebuttal testimony doesn't mention paragraph 36 of the prior settlement, correct?
No, it does not.
And you're not testifying here that the commission erred when it approved that provision in the prior settlement agreement, correct?
No, I'm not. That's not my testimony. I mean, I think this is circled around, can you use RESA funding for energy assistance? And I think that's addressed here. So, and that's my testimony. I'll restate my prior answer. I think there's some challenges with using the RESA for energy assistance. It probably comes down to legal interpretation, and I'm not a lawyer.
That's fair. And you're not testifying that the commission lacks authority to consider a similar approach today, correct?
Again, I feel like I'm getting into some legal grounds here, and I'm a little uncomfortable answering it because I'm not a lawyer.
Okay, that's fair. So just to recap, the commission has already approved RESA funded energy assistance in the form of donated CSG subscriptions for IQ customers, correct?
Yeah, and I'll take a stab at this. I think that's because it's tied to resources, programming. So I think that's the connection there.
Okay.
Direct payment, direct payments from RESA for energy assistance. I think that's the core of what what you're driving at, which I think that's subject to some legal interpretation.
Okay. And nothing in your rebuttal testimony contradicts the authority of the commission approving RESA funded energy assistance in the form of donated CSG subscriptions, correct?
I don't believe so, but again, it's tied to resources. So.
Okay, thank you. We can take this down and pull up EOC hearing exhibit 706. So Mr. Cowan, the Colorado Public Utilities Commission publishes its mission and strategic initiatives on its website. Does that sound accurate to you?
That sounds reasonable, yes.
Okay, great. If we could zoom in a little for everyone's benefit, that would be great. Mr. Khan, do you see here that one of the commission's explicit strategic initiatives is affordability?
I'll take your word for it. The words are really small on my end, but Control F, I'm sure affordability is in here.
If maybe we could zoom in a little bit more, because I'm going to ask you if you see
Last
words.
sentence. Sorry, I see it now. Affordability is a critical part right there. Last sentence of the, yes.
Okay.
Go on, affordability, yeah. Sorry. Excuse me.
It's okay.
It's titled affordability.
You're
so that's
just,
on
yeah.
me. That's on me. Okay.
No worries. So yeah, just to confirm, and you started to read it, the PUC's website here states affordability is a critical part of the commission's oversight as it regulates Colorado gas and electric utilities. Do you see that?
Yes, I do.
And this webpage further states that the commission's mission is to ensure that reasonably priced services consistent with economic, environmental, and social values of our state. Do you see that?
Yes.
I'd like to move for the admission of hearing exhibit 706.
No objection.
All right, hearing exhibit 706 is admitted.
Thank you. So Mr. Cowan, would you agree affordability is a central part of the commission's regulatory oversight?
It appears so.
And in your own testimony within this case, you mentioned both equity and affordability as important considerations for this new RE plan, correct?
Yeah, in fact, we call out equity as one of our general themes to that's in my settlement testimony.
And your testimony also explains that the company must prioritize renewable energy investments and programs for IQ and DI communities consistent with Senate Bill 272, right?
Yes.
And if we could actually now go to your direct testimony, hearing exhibit 101 at page 67. Lines 13 to 16.
Sorry, 101, page 67?
Yes, thank you.
101 on, oh wait, sorry. There we go.
Okay, great. So Mr. Cowan, do you see here on lines 13 to 16 of your direct testimony that you described the company's initiatives aimed at providing equitable access to clean energy programs and reducing the financial burden associated with energy costs for IQ and DI communities?
Yeah, I'm trying to, which particular lines are you looking at?
Lines 13 to 16.
And give me a moment I just want to acquaint myself with it again. Yes. And your question? Sorry.
Just confirming that this is what you stated. So thank you for that.
Yep.
So would you agree that reducing energy burdens for IQ and DI community customers is a key policy objective referenced across commission proceedings?
Yeah, I think that's a directive. It's a good goal, and it comes in many forms. So yeah.
When IQ customers receive no bill savings benefits from approved IQ community solar programs, would it be reasonable for the commission to consider targeted remedies?
I don't know if I can answer that.
Okay. When a commission receives no community solar benefits, or when a customer, I apologize, when a customer receives no community solar benefits, their monthly bill is higher than it would have been had they received those bill credits, correct?
I mean, generally speaking, yeah, if you take a customer who can participate in the garden or is participating in a garden, yeah, the one that participates in the garden is receiving benefits. The one that's not, I don't know their status of, if they're eligible for the garden or not. So, I mean, assuming that they would be eligible and that there's no garden available for them yet, they're not receiving the benefits up to that point.
Thank you. Would you agree with me that the commission has broad discretion in allocating renewable energy benefits and RE plans to meet statutory and policy goals?
I believe that's correct.
And we already said that, or we already established the commission prioritizes affordability for IQ customers, correct?
That's one, it's mentioned. I didn't see it amongst their perhaps other objectives or missions, but you mentioned affordability, showed it to me. I agreed that that's one of them. Yes.
Okay, great. If we could please pull up, I will just say, Your Honor, I have a couple more questions of this section. If we want to take a mid-morning break, just wanted to signal that to you.
I am good with taking a 10-minute break or so. And so why don't we go ahead and do that? Let's reconvene at 10:45. Would that be good for you? Okay. All right. Thank you, everyone. Oh.
That's great. Thank you.
All right. Thanks.
All right, thank you everyone for the mid-morning break. It does appear that we have everyone back. So go ahead and proceed. Thank you.
Thank you, Your Honor. Mr. Cowan, only 3 more topics to cover with you this morning. Appreciate your patience. So if we could pull up EOC hearing exhibit 702, possibly Rev 1. So Mr. Cowan, are you familiar with the Commission's recent decision in the Black Hills 2022 Electric Resource Plan and proceeding 22A-0230E?
Not really, to be honest with you.
Okay. Well, we'll walk through it. If we could turn to page 16, paragraph 42, please. So Mr. Cowan, if halfway down this paragraph, do you see that in this decision, the Commission, I'll just represent to you, the Commission approved Black Hill's proposal to use RESA surplus funds to buy down renewable project costs so that customer rates would be lower. And so do you see here in this decision, in this paragraph, the Commission mentioning the affordability concerns on this issue?
Give me one moment to read this. Yeah, I see affordability and I see it tied to resources as part of Black Hills. Is this what their ERP? Is that correct?
Yes.
So, and what type of resources are we talking about? They're PPAs, but what type of PPAs are they? Are they gas CTs? Are they renewable resources? I assume renewable resources. So I think that's probably something pertinent, maybe.
Okay. Thank you. And I acknowledge that you weren't familiar with the decision previously, but if we could turn to paragraph 28 of this decision on page 10.
Solar projects.
So Mr. Khan, do you see here that the Commission's rationale for using the RESA surplus included customer affordability and managing rate impacts?
I'll take your word for it.
If you look at the last sentence of
solar projects, which the last sentence, okay. Yes.
Thank you. And in your view, does the Commission's approval of a RESA surplus buy down, essentially for Black Hill, suggest the Commission has discretion to use renewable related funds for affordability purposes when customers would otherwise face higher costs?
I understand the affordability angle. However, I see a tie between the RESA and renewable resources. And to my earlier statement, going from that to potentially energy assistance, I might phone a lawyer for that.
Okay. I'm sorry, I apologize. I'm not sure if you answered my question.
Sorry, I'm trying to understand this document all the while. So yeah, the Commission approved a buy down of solar PPAs, I'm reading, for affordability reasons.
So would you, in your view, would this approval suggest the Commission has discretion to use renewable related funds for affordability purposes?
I think for affordability, yeah, I think that's what they're pointing to.
Okay, thank you. We can take this down, and second to last line of questioning. Mr. Cowan, in your direct testimony, you acknowledged that the company made a pricing error in the 2020 standard offer for Solar Rewards Community, correct?
Yes.
And because of that error, the standard offer price was higher than the company intended, correct?
Yes.
Okay, great. If we could pull up already admitted attachment JPD12 to CEO hearing exhibit 400. And go to page 2. So Mr. Cowan, based on the company's discovery response to COSA-SIA CCSA 126, which if we scroll up to page 1, we can just understand that that's the specific question I'm about to ask you. So if we go to go back down, please, to page 2. So based on the company's discovery response to this question, this error persisted for multiple years, correct?
Multiple years. I mean, we found it in November of 2021. Earlier that year, we went under contract, I think in January of 2021. I think that's what the testimony, we have fairly robust testimony on the entire chronology of this. I guess I don't see multiple years as being characterized correctly. I mean, it happened. There was delay in finding it. Yes, I'll agree with you there. So I'll agree basically I'll agree is like some time passed between us signing contracts, between the RFP signing contracts, and then when we noticed the error. Yes, there was a bit of time, months. I also recall this being subject of the 22 through 25 plan that was discussed there as well. So this issue's been out there for a while.
Okay. So just to clarify, so on subpart C, of the discovery response, you say the company's December 2020 information notice contained the incorrect price, correct?
Yes. We had not discovered the error at that time.
Okay. And then in your answer to subpart E, you say that the company disclosed the error in May of 2022. Is that accurate?
In the disclosed, that's in that particular case. We in December of 2021, we brought this to the attention of staff after we were reviewing another, I believe it was the RFP. So it was disclosed then. I think I'm signifying this was disclosed to the broader audience in that proceeding at that time.
Okay. So based on that, the error persisted for at least a year?
Yeah, it was a while. Yeah, a year.
Okay.
Yeah, it's about fair.
Thank you. And we can take this down. In this proceeding, the company is asking the commission to approve RISA cost recovery for the producer agreements affected by this pricing error, correct?
We are, and to add a little color to that, I'm unaware of an error like this occurring. I've been involved with res plans for over a decade now, and unaware of an error of this sort happening. So by all accounts, we've administered programming pretty well. Some might take issue with that for other reasons, but and this was a human error. And we run administer these programs, and we're a company of humans, and error can happen. So it wasn't intentional. And I'd also add that there are benefits. All of those gardens that got that pricing had been constructed. They're up and running. Some of those have actually income qualified components to them. So there are benefits being delivered on those projects today. Sorry, I think a lot of context is necessary for this issue.
Okay, so just to confirm, in the first part of your question, you said the company is asking the commission to approve RISA cost recovery
Yes.
for this pricing
Yes.
error.
Yes.
And that cost recovery request is approximately $12 million, correct?
An estimated $12 million over 20 years.
And the company is asking customers, including income qualified customers, to pay that amount for this error through the RISA, correct?
Customer income qualified customers would be in the the general audience of customers, and they're again they're paying for it, but there's also benefits on the other side of it too. So
okay, so your answer is yes, income qualified customers would be asked to pay for this this error.
I'm not saying them themselves. I'm saying customers in general, which IQ customers are a part of that audience, would be paying for it. Yes.
Okay. And that means the IQ customers, including the thousands who could have been enrolled in IQ Community Solar Gardens approved in the 2022 to 2025 plan, would still pay a portion of the cost of the company's standard offer pricing error through the RISA, despite receiving no bill credit benefits from any of the approved 2022 to 2025 IQ Community Solar Gardens, right?
I'm not fully understanding your question. You're talking about they're paying for it for those. They're paying they're helping pay for the gardens that were constructed as part of the standard offer, 2020 standard offer. And I'm struggling with equating that to the capacity that was made available to the CSG programming as part of the 22 through 25 plan. I'm not understanding your question.
Okay. I will try to rephrase it. I apologize. So based on the company's request for the 2020 pricing error, the company is asking IQ customers, who are part of the largest subset of customers, to pay approximately $12 million for these incorrectly priced contracts, correct?
Customers are going to be paying an estimated $12 million over the course of 20 years for those 23 projects.
And that would include the thousands of income qualified customers who are eligible and could be enrolled in IQ Community Solar Gardens, but are still on the wait list. So you're asking those waitlist customers to contribute towards this issue, correct?
They would be part of that, but they might be receiving other benefits from other programming. I'm not totally liking the isolation of things here, but they would be they would be paying for part of it. Yes.
Okay. So when the company makes an error, it seeks full cost recovery, but when IQ customers receive none of the community solar garden benefits approved for them in the current plan, the company proposes no relief for those customers. Do I have that right?
Well, I'm not exactly agreeing with the premise of your question, because I think, IQ customers have opportunity in other programming, not to mention, an estimated forecasted 2% bill reduction that this plan is forecasted to deliver. So I think we're selecting variables here and saying that direct harm is coming because customers have not been able to enroll in CSGs. I'm a little confused there.
Okay. You mentioned earlier that some of the projects that have come forward and have been interconnected and come online are providing benefits to IQ and DI customers. Did I have that right?
Yes.
Under this error. So even if some of those projects do serve that subset of customers, did the higher standard offered price provide any additional incentives or additional bill credit benefits to those IQ customers beyond what they would have received at the correct price?
Can you restate that again?
Yeah, I apologize. I heard a little bit of choppiness, and I'm not sure if that was me, so I'm sorry. So you mentioned that some of these projects that were that have come forward as a result of the 2020 standard offer pricing error have currently serve IQ and DI subscribers, correct?
Yes.
Did the standard offer price provide any additional incentives or additional bill credit benefits to those customers beyond what they would have received at the correct price?
No, I mean, there's been no, there was no additional incentive or payment to those customers. They get a bill credit. That's what we provided as part of that program. So that's the benefit. And then there, of course, there's the other benefits of, non-monetary of, belonging to a program, the renewable attributes, that sort of thing. So there's benefits there. But I think if you're circled in on the monetary benefits, they get a bill credit. There was no sweetener to it.
And the extra RESA costs created by this pricing error do not increase the bill savings for those IQ customers, correct?
No.
Okay. Last line of questioning at the finish line here. Mr. Cowan, the settlement agreement filed in this proceeding identifies EOC's IQ energy assistance issue as a reserved issue, correct?
Yes.
And a reserved issue is an issue that the settlement does not resolve, correct?
Correct.
And okay, great. If we can now turn to hearing exhibit 1404, which is the Environmental Justice Coalition settlement testimony that was filed in this case. And go to page 9, please. Mr. Cowan, have you reviewed the settlement testimony in this case?
I've reviewed mine.
You've reviewed yours?
Well, sorry, which, let's step back 1 second here. Which testimony did we pull up here?
All right, so here we're looking at the Environmental Justice Coalition, or EJC settlement testimony. So have you reviewed this settlement testimony or no?
I have not reviewed their testimony. I've worked on mine. That's been my focus. And then, I have not reviewed theirs.
Okay. Well, do you see here starting at line 11, EJC similarly identifies EOC's proposed energy assistance recommendation as one of the issues not fully addressed in the settlement. And maybe, I apologize, that's not in the testimony, but so I will move on. I apologize. So do you see here that EJC stated that EOC's proposal would provide relief for IQ customers who have signed up for community solar and would have received benefits had it not been for delays in interconnection or project development?
I guess I don't agree with the way this is characterized, that were never developed. I mean, again, as to previous responses I've given you, there are many gardens in different stages of development. So this assumes that these benefits are never going to be delivered. So I don't know if I agree with that.
Okay, but you see that this is what EJC wrote in their settlement testimony.
I mean, that, again, they're entitled to their opinion, but I don't necessarily agree with it.
Okay. Do you see that EJC further states that it supports EOC's proposal and intentions to realize IQ customer benefits by compensating them for community solar gardens that were never developed? Do you see that?
Yeah, and I take issue with that were never developed. So again, I think there might be a perspective out there that when we make available capacity in a plan, that it's all developed by the end of that plan. And I think that's perhaps an impractical perspective. So saying never is, I don't agree with that.
Okay, but we've confirmed they have not been developed as we sit here today.
So as of today, that's the current status.
Okay. Thank you, Mr. Cowan. No further questions for this witness, and thank you for your time. I appreciate it. I don't know if this is appropriate, but I just wanted to make sure that the exhibits I intended to admit were admitted, or we could wait till the end of the hearing, Your Honor. I'm not sure how you'd want to handle that.
What I know, we can handle it now as far as I'm concerned. What I have is exhibit 704, 711, 705 revision 1, 712, 710, and 706.
Okay. I also intended to move for the admission of hearing exhibit 702. And that is, and I apologize if I did not do that, but it's the Black Hills decision that was issued by the commission in proceeding 25A-0194E. And so I would like to move to admit that decision through administrative notice.
And I can administratively notice that is fine. Okay.
Okay. Thank you so much. And that is it for now. So appreciate it. Thank you.
Yeah, thank you. Mr. Cowan, I do have a few follow-up questions for you, and bear with me. And I'm just trying to seek some clarification, some questions I had before and then that arose earlier today. So my first question for you just out of the gate is regarding the the solar rewards community rollover in general. I see on the chart that it's the $484 million is from billing credits, but can you just elaborate a little bit as to how that number, how it was derived?
Yeah, you basically take the capacity, add a capacity factor and do the 8,760, and then you come up with an estimated production over many years, and then you apply a bill credit rate to that production. And it is an estimate because, it depends on, how many gardens do get developed, what the characteristics of those, those generators are, degradation, you make assumptions upon assumptions to further refine it. So it's really a basic production times rate calculation.
And over the course, how many years, just for my
20.
edification? 20.
20.
Okay.
Yeah. We the solar gardens are a 20-year contract.
Okay. Thank you for that. Then earlier today, you referenced when referring to community solar garden interconnection, you mentioned that the demonstrative exhibit that had the pie chart was a snapshot in time, and that interconnection could be later this month. I understand you can't tell the future, but are there any programs in that hearing, in that demonstrative? Are there any community solar gardens planned on being interconnected later this month?
I don't specifically know that amount. And this is something that's actually shared with stakeholders. We have a quarterly stakeholder group meeting with interested stakeholders, many of them here. And one of the pieces of information that we do show in those meetings is by vintage of year of garden, whether they came out as a standard offer or RFP, where they are in terms of their progress in development. And we have projects from the 2020-21 plan that are still in development, look to be interconnected. We have, part of that could be 22 through 25 projects. And I'd also point to the passage of Senate Bill 24207 opened up interconnection generally. And so we have this open queue where we get projects, and they're not necessarily, they can be specified if the developer wants to or not, but it's an open queue, and it could be for what was our offsite program. It could be CSGs. It could be, larger individual customer installations. So there's, that's kind of like the universe of things that, we can look at in terms of what's looking to be interconnected.
Okay, I think this is a follow-up question to what you just said. generally speaking, how do you expect the prioritization of the 8 megawatts from the CSG from the previous plan to impact the connection of the 26-27 capacity allocation?
I don't, the 8 megawatts of company owned, I don't expect to impact. I mean, last I heard, we were looking to interconnect, those 8 megawatts will be interconnected spring of 2026, first quarter, possibly. That's the last I heard, and that's probably a few months ago. But I don't expect it to impact. I mean, that's our own particular project. There are, you know, many other projects that are out there in various statuses of being developed.
Okay, thank you for that.
Yeah.
And then I think you did address this question later in your testimony, but when talking about that snapshot in time again, you mentioned greening the system, as I understood you to say, and that everyone has benefited. Are you able to articulate a little bit further if there are any specific benefits bestowed upon the IQ community, for example, with regard to greening the system?
Yeah, maybe having been around res plans for quite some time, I mean, as I'm an Xcel Energy customer, I've been paying into the RESA. So if you've been paying into the RESA, you've been part of funding various forms of development of eligible energy resources for quite some time, as part of the RES statute. This goes back many years. And so broadly speaking, when I've paid into that, I'm receiving benefits from a greening system, from utility scale solar projects to community solar projects, offsite, you know, incentivized rooftop. So we're all paying into that. It's a general greening of the system. So from a broad brush, if anyone's paying into it, they are receiving benefits. That doesn't matter if you're qualified, you know, categorized at one point in time as income qualified, or as a, you know, I hate to say it, but a I'll just say non-IQ customer at a certain point in time. So that's that perspective. Now, some additional history is with the passage of Senate Bill 21-272, that directed that when we go through one of these res plan proceedings, that we start trying to target and plan for certain investment to target IQDI customers. So, and the first iteration of that was really the 22 through 25 plan. And, you know, the jury's still out on, you know, if we've done that well. I would say that, you know, that was the first plan, and actually exhibited in this settlement agreement with our agreement to work actually with a targeted stakeholder group. We're going to be able to make refinements along the way. So I think that gives you a complete history of, like, yeah, everyone does receive benefits. But then here more recently, in recent years, we've been targeted a little more specifically for IQDI customers.
Thank you for that clarification for me. I do have a few questions about the 2020 Solar Rewards Community Standard Offer issue. And so the first question is, has public service been making full payments on those contracts throughout the entirety of, since they were executed?
Not since they were executed. We start paying the bill credits when those projects are interconnected. So we have 23 projects that have been interconnected at various times. I know that they are all interconnected as of this point, but it's at various points in time when, you know, that actual production from those projects has occurred.
Okay, so I think then have there been any penalties or interest accrued because of the mathematical error that would be passed on to the ratepayers? And I think that obviously I don't understand exactly the mechanics of how these sort of contracts work, but the question I have for you is that 12 million approximate amount of money, does that include any sort of penalties associated with the contract payments?
No, not specifically, no. I mean, if in my testimony, again, we have some pretty robust testimony on this subject. At one point in time, we went back to developers to try to mitigate that in certain instances. We're unsuccessful. In fact, we heard from the commission during one of their moments where they actually voiced, had communication on this subject, that they thought that, there was a case of mutual mistake. And I'm not a lawyer, but I think that's a specific legal term. And that's what forced us to go back to the developers and say, hey, can we do something to mitigate this? To which we were unsuccessful doing that. But any sort of specific penalties, no.
Okay. Yeah, no, and you definitely answered my question. I'm sorry, I'm having a difficult time. So I think maybe then my high level question, and correct me because I might completely misstate the mechanics of this, but that $12 million, how are those funds transferred? Meaning, are you proposing to do a yearly payment from the RISA for each of the 20 years, for that $604,000 each year? How does this work? What Public Service is proposing, how does that work logistically to get that payment?
I mean, they're funded. I mean, it's the bill credits at an elevated price, and the bill credits are funded out of the RISA.
Okay, thank you.
Yeah.
Thank you for clarifying. I was missing a little component there, kind of a key piece. Okay. And then I do have just a couple of general questions about the application. They're not specifically addressed or are different than what is in the settlement agreement. I will ask you if you don't know the answers. That's okay.
Good.
Yeah. So at one point, I'll just say, so in page 13 of the application, I don't know that we will need to pull it up, but you're welcome to correct me if you do need it to be pulled up. But it says that the company is not proposing any changes to Renewable Connect Flex, previously known as WindSource. And then the settlement agreement doesn't mention that program. Does that mean that is what is in the application is still what Public Service is requesting?
Yeah, that program will simply continue on.
Okay.
You're correct in that's the former WindSource program, and it changed because of the last res plan, and with no modifications, the intent is it goes forward as is.
Okay. And then on a somewhat similar note, in the application initially, Public Service was requesting to enable flexible interconnections through an addendum to its standard interconnection agreement that was in volume 3 of the RE plan. And in the settlement testimony, though, it appears that is no longer the case in light of an expected forthcoming commission order. Can you just clarify that if the latter statement about Public Service's position in the settlement testimony is the current position, and that Public Service is not seeking to get approval of those contracts as was in the application?
Correct. Yeah, I think
Okay.
in fact, I mean, I work in both cases, and I think we heard pretty loud and clear from verbal deliberations from the commission that they're going to be ordering us to file a tariff for flexible interconnection.
Okay. Thank you for that. I just wanted to, my questions are just to get a little clarity for myself as I'm going through everything. And then I did just have, can you, big picture, just explain for me why there are no estimates for the Resilience Hub capacity and budget in the proposed settlement agreement? And if you're not the right person to ask, that's okay too.
I mean, that deals with a rollover or utilizing some rollover capacity budget from from this 22 through 25 plan. I know that's the source of it, but I would hand that to my colleague, Mr. Murphy. I think he's a little bit more dialed in on that.
I will, yes, that I can do that. That's good. And okay, thank you. Those were my only questions for you. I really appreciate your time.
Oh, thank you.
Thank you. And Ms. Shields, did you have any? I imagine you do. Just first of all, do you? Yeah, and then do you have an idea about how long you think you'll be, just for planning purposes? The answer doesn't matter.
I would anticipate perhaps up to 30 minutes.
Okay.
Hopefully we can do it quicker, but.
Sure. Go ahead. Please proceed. Thank you.
Great. All right, Mr. Cow, I want to pick up on one really quick item that the ALJ just asked you regarding the Community Resiliency Hub solicitation. If we could pull up hearing exhibit 113, the settlement agreement at page 18 and paragraph 50. I understand you that you had indicated Mr. Murphy might be a good witness to ask this question, but Mr. Cowan, if you could just briefly look over paragraph 50 and perhaps give a high-level summary of your understanding based on this paragraph of how the Community Resiliency Hub solicitation will be funded.
Yeah, my understanding is that it is funded based on unallocated capacity from what is the Solar Award CNI program as part of the 22 through 25 plan. And, you know, that's a budget of up to or to not exceed 5 million. And I think that comes through a solicitation as well.
Thank you for that. I just wanted to make sure I did not miss that since it was fresh in our mind. I am now would like to take you kind of roughly back, probably more or less in order of where you began with Ms. Canelio. And at the outset, you had quite a lengthy exchange with Ms. Canelio about the community solar garden capacity, particularly IQ, DI community dedicated capacity that has been interconnected during the pendency of the 22 to 25 RE plan. You recall a lot of that exchange, correct?
Yes, there was a lot of discussion around that topic.
Now, I understand you're not a lawyer, but is your read and your understanding of the commission's 22 to 25 decision and the settlement agreement that it approved, that the company is obligated to interconnect all awarded community solar garden capacity prior to the expiration of a renewable energy plan?
No, I'm not aware. I don't. The commission has not ordered that. I mean, we make available capacity for these programs. You know, that capacity can be certainly interconnected. It can be in various stages of being interconnected. But to have the perspective that capacity is interconnected by the last day of a certain plan is not what's ordered by the commission or guaranteed, you know, required.
And I mean, given your experience with these programs, do you think, particularly with respect to the 22 to 25 RE plan, that it would even be possible to interconnect the CSG capacity that was made, the full amount of CSG capacity that was made available during that plan?
No, and I mean, a couple things I would add, and earlier in our exchange, my exchange with Ms. Canelio, I pointed out like how this program is rolled out, you know, over time, and you know, it certainly didn't start, you know, all available, you know, at a point in time, you know, for the full 4 years, so yeah, it didn't start necessarily right at the beginning of the 4 years of the plan. When in fact, the plan was approved almost a year after it was filed, final approval. So, you know, that's kind of important, and it just takes, these are long lead projects, and so it does take time. But I think the anticipation that all of that capacity being interconnected by the end of the plan is somewhat of an unrealistic perspective.
And just to make sure that we're all on the same page, when kind of in this exchange, when we're talking about interconnecting capacity, does that mean actually energizing a community solar garden, or are those more or less the same thing?
when you say it's interconnected, it means it is hooked onto the system. It is, producing electricity. That's when it means interconnected. But then from there, there's various stages of interconnected. I mean, you have to study the project for where it is on the system. There might be upgrades involved. There might be upgrades to distribution, transmission systems. There's, there's the permitting. There's a variety of things that need to happen for a project to ultimately be interconnected and producing electricity. So interconnected, I think in this context, means it is on the system, energized, and producing bill credits.
Yeah, and I think at one point during your cross-examination, what you explained, you used the word, there are many variables. And perhaps you may have even said variables outside the company's control in actually energizing or interconnecting a CSG. And
Yes.
could you help elaborate a little bit on kind of what some of those variables are throughout the interconnection process? From the time the company makes available capacity, whether that's through an RFP or a standard offer, and the time that a facility interconnects or becomes energized.
Yeah, and I believe I said that, I don't have direct, I have some experience with these projects, but I'm not a solar garden developer. But I am aware of some of the variables, and goes from land acquisition, permitting, supply chain, contracting with what they call an EPC or engineering planning and construction firm, financing the project. There's the where it's placed on the system. Are there again interconnection upgrades that need to occur to the system to make it possible? Yeah, there's a lot of variables outside of the company's control.
And I think at one point there was some testimony from Mr. Felder that had been flashed on the screen, where you were talking a little bit about the timing of being able to release the CSG capacity. I think at one point you had been talking a little bit about that there were some factors that went into developing a new interconnection study process during this RE plan.
Yes.
Could you elaborate on some of the regulatory and stakeholder aspects that were kind of occurring behind the scenes in order for the company to be able to actually launch and make available the CSG capacity under the 22 to 25 plan?
Certainly. So in 2023, what set up the program was we held an RFP, and this is in line with the settlement agreement of the 22 through 25 plan. That had to occur first, and because that set the pricing for the standard offer. Knowing that, and then based on that solicitation, we then had to file a motion with the commission to inform them of that pricing, how that solicitation went, etc. Knowing that there would be a possible large amount of projects looking to be studied, we public service, a number of us, I was part of that group, worked with the then executive director of COSA, also a member of CCSA, to develop a process to bring in tranches of capacity to be studied. That was actually all called out in a motion that we filed that, again, stated the price of the solicitation. And then we basically called out this process that we were going to go through on interconnecting, because we wanted to move things smoothly. We didn't want to create a bottleneck. So that had to occur, and that took us well into 2020, beginning of 2024. And then I think I also mentioned that things changed. Senate Bill 24207 was enacted, was approved, or was signed into law over the summer of 2024. And so we had to go back and then scrap that interconnection queue approach to then have this open interconnection queue, the one that we have today. So there's been a lot of work, a lot of engagement with with certain parties to try, with good intentions to make sure that the program would run smoothly. So again, when I saw that line of testimony saying that we did a poor job, I don't think that is I don't think that's accurate, and I don't think it respects the engagement we had with parties.
Ms. Canelio asked you a couple of questions about, I believe, a reference 306 megawatts of capacity that may need to be made available under the settlement agreement. Do you think that all of the effort that went into developing the interconnection process leading up until now should facilitate maybe more expeditious, interconnection processes for the projects that are contemplated in the settlement agreement here?
Yeah, I do think that will help. I mean, we've been taking our interconnection processes seriously for quite some time now, and we have an open interconnection queue. Again, we have projects at various stages, so we could see projects, happen very quickly. Again, I don't know the status of each and every one of those projects. I just don't know their general. I mean, I'm aware of their general status, and then we share that status again with stakeholders at our quarterly stakeholder group meeting. So I mean, I believe that we are positioned to do the best we can, considering circumstances of what we know of today.
I think that's a good segue. If we could pull up hearing exhibit 115 from the companiesbox.com. And while we are pulling that up, Mr. Cowan, both Ms. Canelio and then again, the administrative law judge asked you some questions, or you at least provided some responses referencing the current interconnection status of various community solar reward or community solar garden projects and projects that are within the interconnection queue. This document in front of you, does this look like a reasonable and accurate copy of the third quarter 2025 review and updates that came out of the company's renewable energy standard quarterly stakeholder meeting?
It does.
Okay. And are you familiar with this document? Have you seen this?
Yes.
Okay. If we could scroll to, well, I will move for admission of this exhibit. I'm happy to continue asking questions to lay more foundation for it, but would move for admission of hearing exhibit 115 at this time.
Yeah, and I'll admit hearing exhibit 115.
If we could scroll to page 17. And Mr. Cohn, could you tell us, could you give an overview of what this particular table demonstrates?
Well, I mean, it's aptly named the rainbow chart because all the colors, of course. But really what this shows is the capacity that, by vintage of, whether it was a solicitation in that year or standard offer, but it shows the status of the various vintages and where they are in the whole process of going active, being interconnected, if you will. All the way from capacity was completely withdrawn. That can happen. But if you look further down this table, you'll see that, especially if you go to the right side, where more recent vintages, all the way from 2020 through 24, where they are. And what I can, discern from this is we have a fair amount of capacity that is in study review. We are in design and an interconnection agreement that's been issued. It's 35 megawatts. Or we have a sign and it's in construction on its way to becoming interconnected. So there's a fair amount of capacity, I'd say, in later stages of progress here. I'd also point to, since this has been, the topic's been here for the 22 through 25 plan, you can narrow in on where those, that capacity is, and gives you a real sense of, what's out there, what could be, fully interconnected. So I think this gives you a lot more context around where various projects are. And you compare this to that discovery exhibit that was presented earlier. That was, addressing a specific question about how much of this particular plan has been interconnected. And, it's a very targeted, that's a very targeted question. We answered it correctly. I believe, we answered it correctly, but this gives you a really idea of where things are.
And so particularly in this table, looking at years 2023 and 2024, would those years reflect capacity made available under the current 2022 to 2025 RE plan?
Yes.
And so I think what I heard you say, but to confirm, would you say that this is a more accurate reflection within 23 and 24 of the status of 2022 to 2025 RE plan capacity?
Yeah, I think this is more accurate. It shows you more of the status of where things are.
Turning gears just a little bit, under the settlement agreement in this proceeding, the company has agreed to roll over capacity, SolarWard's community capacity from the 22 to 25 RE plan and make that available as part of the 26 to 27 RE plan, correct?
Correct. We agreed to that, yes.
Okay. And so you were asked some questions by Ms. Cornelio about waitlisted customers, particularly IQ customers who are who may be interested or waitlisted for community solar garden programs. I believe the figure she had thrown on the screen was about 9,000, which I don't believe you necessarily agreed with that figure, but do you remember that line of questioning with her?
I do.
Okay, so regardless of how many IQ or DI community customers may be waitlisted for Solar Rewards community or ICS subscriptions, would those customers be eligible for Solar Rewards for community solar garden capacity or ICS capacity under the 26 to 27 plan?
I believe, yes, they would be.
Thank you for bearing with me as I work through my notes here. Now, you also had a number of, Ms. Cornelio asked you a number of questions related to the, I think what she described as the benefits of bill credits that community solar garden subscriptions provide to customers. Do you remember some of that exchange?
I do.
Okay. And when do customers start receiving bill credits for a community solar garden?
I mean, once they become a subscriber to a garden, then I believe within a month or so. I mean, I'm sure there's some processing, but pretty soon after being a subscriber, they start receiving bill credits.
Okay, but to be clear, a community solar garden would need to go into service. It would need to be energized first before a customer could start receiving those benefits, right?
Oh, correct. Yeah, you need to have a interconnected, energized, producing electricity project. Yes.
Okay, so is capacity that is currently in progress on this hearing exhibit 115, is that actually becomes active or energized? And then as well as capacity that's agreed to under the settlement agreement, is that capacity becomes energized, customers will start receiving bill credits for that, correct?
Yes, correct.
Okay. Now on the flip side, bill credits are, I mean, those come at a cost to all customers, is that correct?
Oh, correct. Yeah, they go into, they're funded through the RISA and they're paid, the RISA is paid by all, all customers that, there are customers. So yes,
Okay.
they're socialized, if you will. They're socialized amongst all customers.
Okay. So even once community solar gardens go into service, all customers are effectively subsidizing any bill credits that are afforded to any customer. That's an IQ customer, a DI community customer, or a regular retail customer.
Correct.
Okay. I'm going to pivot and ask a couple of questions related to the RISA. You just mentioned the RISA, so let's go there. At the outset, Ms. Canelio asked you a question asking, I think, something to the effect of whether the current over-collected RISA balance of approximately 150 million, if that's the result of spending being below budget on IQ equity type programming or other types of renewable energy programming. Do you remember that line of questioning?
Yes.
Okay. And again, recognizing you're not the RISA expert, but have certainly been involved in RES programs for a while. What is your understanding of the primary driver of the RISA over collected balance right now?
I think the primary is that most of there are many, many variables that go into the RISA. It funds many different things, but I think the primary reason is that we have, over time, a lot of resources have not generated what we call incremental costs, therefore being an expense against the RISA. So we have a RISA that's been, going at a very consistent clip in terms of the collection. We just haven't had like a lot of the utility, for instance, utility scale resources that have been drawing from the RISA because their incremental costs are actually below, they're below avoided costs. So that's created this relatively large, I believe one of the bigger reasons why we have a large balance. And the company's been paying interest on that at its WACC for many years. So, but you can't attribute it to like a CSG program. There's many other variables and there are other larger variables. So I believe that's the major one is we have utility scale resources that are below avoided costs.
Okay, and then would you expect that the RISA reform, so to speak, that's agreed to as part of the settlement agreement, that stands to mitigate the over collection of the RISA balance?
I do. I think, it's probably one of the benefits of the settlement agreement plan going forward is to draw down that balance, which will then generate what we estimated as a 2.05% bill impact to residential customers. So that's a bill reduction. It's also allocating resources, what I believe is to their appropriate place. You're taking the more system resources and putting that to the ECA, whereas the retail DG resources are going into the RISA. So I think the assignment is a little cleaner, a little more transparent. And there is that benefit of a forecasted bill reduction.
Yeah, and while we're there, you'd had a number of questions related to kind of conceptually or more broadly to the question of affordability with Ms. Canelio. And so would you agree that under the settlement agreement that the use of over-collected RISA funds will address affordability concerns?
I mean, by reducing the overcollected balance, I think that helps address affordability.
Mm-hmm. And just two quick more questions on the RESA. Is it the case that RESA collections don't necessarily just fund expenditures contemplated in a current plan, but also costs associated with prior plans?
Oh, yes.
Okay. And is it the case that prior plans have funded resources, eligible energy resources that serve IQ and DI community customers?
Yes.
Okay. So the RESA is currently funding programs that support IQ and DI customers, correct?
Correct.
Okay. If we could pull up, I'd like to transition just a little bit and talk a little bit about EOC's bill assistance proposal and the company's concerns with it, as you've begun to discuss. If we could pull up hearing exhibit 700, which is the answer testimony of EOC witness Andrew Bennett. And if we could scroll to page 34. And Mr. Cohen, if I could give you, I'd like to give you a moment beginning at line 8. And if you could recap or just briefly review lines beginning with line 8 on page 34 up through, let's see, line 9 on page 35.
I'm ready for the next page. Can we go to page 35, please? To what line are we going to here?
Great. And let's see, down to the next page through let's see, I am looking through line 11.
Okay. Okay.
Okay. And so just having kind of refreshed your recollection at some of EOC's testimony in terms of their proposal regarding bill assistance, in your read of EOC's answer testimony proposal, are you familiar with anything in their proposal that suggests that overcollected RESA funds would be used to support eligible energy resources?
Can you restate that again? Sorry.
Is based on your read of EOC of Mr. Bennett's testimony, is EOC proposing that RESA funds, that the overcollected balance be used to support eligible energy resources?
No, what I read is that they made a calculation based on certain, the assumption that program capacity should have been interconnected, and they came up with a calculation. They derived this $25 million number.
Okay. And so in the brief review that you had done of, for instance, that you had seen of the Black Hills decision, again, which I understand you're not particularly familiar with, as well as the past RES plan where there was a provision regarding donated CSG subscriptions, is your take that EOC's proposal in this proceeding is very different than either of those scenarios?
I think it is different. From what I could gather from the brief interaction on the Black Hills, that's dealing with a buy down of renewable resources. And the other one, it was a form of bill assistance, but again, they're tying to renewable energy resources in both instances. So I think this is different from those other two.
Okay, and so, I mean, is the company fundamentally opposed to the concept of bill assistance?
No, I mean, no. In fact, our electric rate case that we filed here a couple weeks ago, maybe less than that, proposed a very robust energy assistance program in that case. So I'm not familiar with all the details, but from what I know of, it sounded like it was robust.
And so, I mean, with that, could you just help elaborate a little bit more on what the company's core concerns are with EOC's proposal to funnel $25 million toward bill assistance?
From what I know, understand is, can you use RISA funds for that purpose? And my read, my non-lawyer read of, everything that deals with the RISA, the RES, the RISA, the RISA itself, is that's used for eligible renewable energy resources, programming, mixture of programming around those resources. So I think these are two different categories of things that, they're not the same thing.
Okay. Do you feel like, based on your review of EOC's answer testimony, that they've put forward a sufficiently developed proposal as to how the $25 million would be distributed through bill assistance?
Yeah, what I read is, it's a calculation. They came up with $25 million, $5 million over 5 years. There's a lot of details to be, I'd say, that need to be figured out. Like, does that money go to EOC? How often does it go to EOC? Who's eligible to receive the money? There's just a lot of detail that's not in the testimony on how they would approach that $25 million. So.
And are you aware of any financial analysis or support that EOC put into the record regarding its proposal?
No.
All right. I think the last area that I'd like to go with you, let's see. Sorry. One more quick question on the RISA over collection. I just, under the settlement agreement, do the settling parties agree that the over collected RISA dollars will be used to support renewable energy programming for IQ and DI community customers?
No.
I'm sorry. Under the settlement agreement, do the settling parties agree to use over collected RISA dollars to generally support RE programming for IQ and DI community customers? And apologies, I'm no longer asking about the EOC bill assistance proposal.
I mean, we're reducing that. I mean, there is a benefit in that we're reducing the overall balance. So there's a benefit there, yes.
And under the settlement agreement, I think at one point in your exchange with the ALJ, you had mentioned Senate Bill 21272, which has a kind of a requirement that the companies set aside or plan a minimum amount of RE plan dollars for IQ and DI community customers. Is that right?
Yes. No, I mean, we've designed programs through, the settlement process to target dollars that take into account that metric that's, present in Senate Bill 21272.
Okay. And the settlement, in your view, the settlement agreement complies with Senate Bill 21272's minimum budget requirement, correct?
Yes. I mean, it's, planned investment in programming directed to IQDI customers.
Okay. The last area that I wanted to go before we can get you off the stand until lunch is finishing up with the 2020 standard offer. And I just, Ms. Canelio had a handful of questions about you on this, and I was just hoping that perhaps you could kind of tie it together and provide all of us with a little bit more of an explanation as to what the company's policy rationale is that would support allowing the company to recover the costs associated with the 2020 standard offer contracts.
Yeah, I probably put into some of this detail that, this was generated from a human mistake. The company is comprised of humans, so mistakes will happen. I'm not really aware of, this type of, mistake happening in res, the programming that's supported by, the res or the RESA. So this is somewhat, novel. Just haven't experienced it. So, that's some perspective on it. I mean, the company deals with, hundreds of contracts, during a year, thousands perhaps, and are mistakes made there? Probably. Again, a company full of humans, so mistakes will happen. We tried to mitigate. The contracts. Unfortunately, unsuccessful, but they have 23 projects that are up and running, providing benefits to this, to the subscribers, to the system. So, I mean, that's kind of how I view the 2020 standard offer mistake. And I just also add that, I mean, we run these programs, we've run them for, many, 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 many years. And really we do it with there's no PIM associated with these programs. So it seems, we have we have benefits from projects that are being delivered. And so it seems a bit much to essentially be penalized, this. So that's generally my perspective on it. And I think, there's a robust record, in my direct rebuttal testimony that explains everything.
I think that's, and I think you may have mentioned this at one point, but I just wanted to confirm, you'd mentioned with the customers have been benefiting from the company's renewable energy programs. Of the 2020 standard offer projects, are all of those projects in service?
Yeah, all 23 are in service.
Okay, and they're subscribed and providing bill credits to a mix of retail, IQ, DI community customers?
Yes.
With that, I have no further questions for the witness.
Thank you. I appreciate that. And Mr. Cowan, thank you for your time. I appreciate you being here today. And
thank you.
So you are excused now. I think now is a good time to do a lunch break. I will propose coming back at 1 o'clock. Yes, Ms. Go ahead, Ms. Nelson.
I just thought it would be helpful for planning purposes to let you know that UCA has decided after Mr. Cowan's testimony has been complete that UCA intends to waive the cross-examination that was previously reserved for Mr. Bennett.
Thank you for that. Okay, I appreciate that. I still think it's appropriate. Oh, Ms. Shields, go ahead. Yes.
Oh, yes, I was going to say the company also intends to waive cross-examination of Mr. Bennett.
Okay. Okay. All right. Well, I personally need a midday break. I don't wish to power through till we complete this. So I can pay good attention and take good notes. Is 1 o'clock. What do you think, Ms. Shields? Does that work for you, or do you have a different suggestion?
That works for us, although I see Mr.
Yes.
Cox has his hand up as well.
Yes, I just saw that as well. So yes, Mr. Cox.
I just wanted to join the party, and staff will also be waiving on Mr. Bennett.
Okay, all right. Well, I appreciate that. I still might have some questions for Mr. Bennett, however. So with all of this in mind, Ms. Nelson, did you have another point? Oh, okay. All right. No problem. Ms. Shields, what do you think about reconvening at 1? Does that work for you, or is that too long of a break for you?
No, that works for the company quite well. And I believe that next step in order is Mr. Patrick Murphy for the company.
Yes. And so do you know, does that work for Mr. Murphy as well to be available at 1?
I believe that it does, yes.
Okay, great. Well, let's do that. Let's go off the record now and let's come back at 1 o'clock. I appreciate everyone's time.
Thank you.
Thanks. All right, let's go back on the record in 25A-0194E. Before we go ahead and resume with the testimony, does anybody have a matter that needs to be taken up now that for any reason? Okay. It doesn't appear that we do. So why don't you go ahead, Ms. Shields, and present the next witness, and then we'll get him sworn in and get going. If you're ready. If you need a minute, let me know.
Thank you, Your Honor. Lauren Caliendo for Public Service, and I'll be calling our next witness.
Yes,
Public Service
my apologies. Yeah.
Thank you. Public Service calls Mr. Patrick Murphy.
Thank you. Mr. Murphy, would you please raise your right hand? Do you swear or affirm that everything you say is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Great. And before you proceed, can you just let me know, do you have anybody with you right now who's communicating with you as you testify?
I do not.
Okay, great. If that changes, just go ahead and let me know. But Ms. Caliendo, you can proceed, but I know you're just going to offer him up, but go ahead.
Sure. Mr. Murphy, please state and spell your name for the record.
Sure. My name is Patrick Murphy, PatrickMurphy.
Thank you. And by whom are you employed and in what position?
I'm employed by Public Service Company of Colorado. I'm a manager of program policy and strategy in the regulatory department.
Thank you. And did you adopt hearing exhibit 102, which is the direct testimony of Deborah E. Irwin? And did you cause to be filed in this proceeding hearing exhibit 105, which is your supplemental direct testimony, and hearing exhibit 108, which is your rebuttal testimony?
Yes, I did.
And if I asked you those same questions today, would your answers be the same?
Yes, they would.
Thank you. The witness is available for cross-examination.
Thank you very much. Go ahead and proceed.
Thank you, Your Honor. Good afternoon, Mr. Murphy. For the record, my name is Casey Canelio, and I represent Energy Outreach Colorado. We've met earlier, and I actually crossed you this past summer during a painful bout of technical difficulties on my part. I'm feeling good about my internet connection today, and I just have a short set of questions for you.
Nice to see you again, Ms. Canelio.
Thanks. Mr. Murphy, were you listening to your colleague, Mr. Cowan's hearing testimony earlier this morning?
I was, yes.
Okay, great. Do you recall that Mr. Cowan testified that the company believes that it can interconnect roughly 306 megawatts in order to qualify those projects for IRA tax credits?
I believe Mr. Cowan testified that the company is going to make available approximately 306 megawatts in 2026 for the ICS program. So that those projects may be able to claim those tax credits.
Okay. Do you also recall that Mr. Cowan testified the company couldn't possibly interconnect 165 megawatts over the last 3 years of the current plan?
I don't recall Mr. Cowan saying that. Sorry.
That's okay. Do you recall when Mr. Cowan testified that fully interconnecting the 2022 to 2025 approved capacity by now was an unrealistic perspective?
I think Mr. Cowan, if I recall correctly, I think Mr. Cowan was speaking to the time that some of these projects take, specifically community solar garden projects, as they take time to fully develop. So if I recall correctly, he was stating that it's somewhat unrealistic to think that project, all capacity that's made available for the 2022 to 25 plan would be fully developed and interconnected and energized, by December 31 of 2025. It's certainly feasible that some of these projects will, bleed over into additional years.
Okay. So based on his testimony earlier today, even completing the approved capacity for the current plan was not feasible. Would you agree?
For the 22 to 25 plan?
Yes.
Yeah, I mean, we make our best efforts, right? The company makes available the capacity. Then there's several factors at play for these projects. Again, they are longer lead time projects. They require developer interest, customer interest, they have to go through the interconnection process. So there are many factors at play that contribute to the time that it takes to fully develop and see these gardens come online.
Okay. Thank you. If we could please pull up hearing exhibit 115, which was brought up during Mr. Cowan's redirect by Ms. Shields. The rainbow chart. And I apologize, I'm not sure which page number the rainbow chart is on. Can I phone a friend to Miss Caliendo to let me know?
Yeah,
I'm sorry.
It's page 17.
Thank you so much. I apologize.
No problem.
There it is. Okay. Mr. Murphy, so looking at this, the rainbow chart, the company owned 20 megawatts for IQ customers approved in the 2022 to 2025 plan are not in the construction phase, correct?
They are not, as Mr. Cowan discussed earlier, the company is focusing first on the 8 megawatts of IQ CSGs that we have that we're currently moving forward with, and then we'll make the determination as far as what we're going to do with the 20 megawatts that were approved through the 22 to 25 plan.
Okay. I want to come back to that that statement, but so and as we can see in this chart, those 20 megawatts, they're not in the in-study review phase or anywhere. They're just not in, they're not accounted for in the rainbow chart, correct?
The companies specifically, Ms. Cornelia?
Yeah, the 20 megawatts of company owned.
Yeah, those that were approved in the 22 to 25 plan would not appear in here. That's my understanding.
Okay. So based on your statement, the company that these 20 megawatts, they haven't even taken the first step towards interconnection, right?
Again, right now we're focused on the 8 megawatts that we are currently moving forward with.
Okay. So based on that, I just want to confirm those 20 megawatts haven't even taken the first step towards interconnection.
That's my understanding. Yes.
Okay. Thank you. And just looking at this, the columns of the rainbow chart, there's no column for 2022 capacity, probably because of the timing of the commission approval of the 2022 to 2025 plan. Is that fair to say?
Yeah, that's my understanding. We did not receive a final commission decision until November of 22 of that plan. So that would be why 2022 is not reflected in this table.
Okay. So looking at the 2023 column, and in that year, the company interconnected about 54 megawatts under the SRC program. Is that accurate?
That's what I'm seeing, yes.
And in 2024, the company interconnected 80 megawatts. Is that accurate?
Approximately 80 megawatts. Yes.
Okay. So in the past 2 years, the company's interconnected a total of 134 megawatts. Is that right?
Well, actually, I don't know if it's fair to say that those were interconnected. Those are all at different phases in all of those years, as you can see.
Oh.
So the total at the bottom is totaling up the application, those that are in study and review, those that have an interconnection agreement issued, all of the different columns under the capacity by vintage.
I see. Thank you for that clarification. So based on what's in the blue active row, it looks like it's just 0.2 megawatts for the SRC program
for
2023 and 2024.
That's what it looks like. Yes.
Okay. Thank you. If we can now go to EOC's hearing exhibit 710, which is the settlement agreement from the current RE plan, and go to page 52, which is the kind of attachment and budget table that I went over with Mr. Cowan. So if we could zoom in to the company offered income qualified solar rewards community row, which is kind of halfway down So Mr. Murphy, this table shows that for that collective 20 megawatts of company-owned CSGs for IQ customers, 5 megawatts of company-owned capacity was allocated in 2022, and then 5 megawatts in 2023 and 5 megawatts each for 2024 and 2025. Is that accurate?
That's how it's shown in the table, yes.
Okay. And so not even the 5 megawatts that have been allocated for 2022 or 2023 have taken the first step towards interconnection. Is that accurate?
Well, again, 2022 does not appear in that rainbow table. We did not receive a commission decision until November of 22. So we do not have anything for that. And again, the company is focusing on completing the 8 megawatts that it currently has moving forward before it does any additional work in this space.
Okay, thank you. That actually brings me to my next question. Mr. Cowan testified that the legacy 8 megawatts of company-owned IQ CSGs would not come online until spring 2026. Do you recall him stating that earlier today?
I do, yes.
Okay. I'm sorry to make you do some light math, but Mr. Murphy, can you confirm how long it will have taken from the commission approval of the legacy 8 megawatts at the end of the last plan, the 2020 to 2021 plan, until its anticipated completion and interconnection in spring of 2026?
I was not part of that plan, so I honestly have not been close to the company's development of those solar gardens, so I'm not sure exactly when we began the process compared to the estimated completion in spring of 2026.
Okay, but if those 8 megawatts were approved in the 2020 to 2021 plan, and if that plan was filed before the current plan that we're talking about, likely in 2020, it'll take maybe at least 6 years for those 8 megawatts to come online.
Depending on, well, I don't know if it's, I don't know the exact timing of when the company actually began the process of developing those, but I would agree with you that it's taken, a few years for the company to work through this process and actually get the garden online.
Okay, thank you. And given that this timeline of the legacy company-owned 8 megawatts, there's nothing in the record in this case indicating when any progress will occur on the 20 megawatts of company-owned gardens approved in the current plan. Do you think that's accurate?
Yes, again, the focus right now is completing the 8 megawatts that we have currently estimated to be online by the spring of next year. I don't know where the additional 20 megawatts stands at this point.
Okay, because you testified a couple minutes ago that once the legacy 8 megawatts is completed, which the company thinks will happen spring of 2026, you said the company will make a determination on the 20 megawatts of company-owned gardens under the current plan.
I don't know where that process stands at this point. The focus is just on completing the project that we currently have moving forward.
Okay. So in light of the company's past interconnection performance and Mr. Cowan's testimony about feasibility and the current status of the 20 megawatts of company-owned capacity, the company is still representing that roughly 306 megawatts will be available and possibly interconnected in time for the full IRA tax credit. Do I have that right?
The company is making that capacity available. Again, there are other factors that come into play here. There's certainly market dynamics, there's developer and customer interests that play a role in this. And so, the company is making it available after working with parties in this proceeding and understanding the current federal policy and the removal of those tax incentives. So, we're trying to do everything to help the industry be able to claim some of those incentives.
Thank you. Last question. Can you confirm that there's nothing in the pending settlement agreement for the 2026 to 2027 plan that addresses that 20 megawatts of company-owned IQ community solar gardens?
I think that's accurate, yes.
Okay. Thank you, Mr. Murphy. Those are all my questions.
Thank you.
Thank you. And it looks like actually my questions that I had written out have actually already been answered. So I don't have any questions for you, but you may have some redirect questions now.
Thank you, Your Honor. No redirect.
Okay, well, thank you for your time, Mr. Murphy. I appreciate you taking the time to be here today. Great. And I understand those were the only witnesses that public service was going to have that were subject to cross-examination. And it looks like Mr. Bennett. Now, I understand the parties have waived their cross-examination. I did have a couple of questions for Mr. Bennett. If he could still be available for testimony, that would be great. And would you mind, Ms. Canelio, if you just asked him the basic questions leading up to my questions, just stating his name and all that? I could do that if you like, but if you don't mind, but I'll swear you in first, Mr. Bennett. Would you raise your right hand? Do you swear or affirm to tell the whole truth and nothing but the truth under penalty of perjury?
I do.
All right, thank you. All right, Ms. Canelio.
Thank you, Your Honor. Mr. Bennett, could you please state and spell your name for the record?
Certainly. Andrew Bennett, Andrew, Bennett, Bennett.
And by whom are you employed and in what capacity?
I'm employed by Energy Outreach Colorado, or EOC, and I'm the Vice President of Advocacy.
And did you cause to be filed in this proceeding, hearing Exhibit 700 Rev 1, which is your answer testimony?
I did.
And if you were asked those same questions today, would your answers be the same?
Yes.
Assuming I didn't forget anything, Mr. Bennett is available for Your Honor's questions.
Thank you. I appreciate that. Thank you for being here today, Mr. Bennett. I just have a few sort of high-level general questions for you. As you know, EOC requests that public service allocate $5 million a year for 5 years to energy assistance programs. Can you tell me which program specifically?
Certainly. So EOC has an energy assistance program. I think maybe the plural is maybe a misstatement. So we have different funding vectors. So some comes from House Bill 21-1105, independent fundraising, investment returns, and individual donors. That money is collected, and then some funds are restricted for utilities, depends on how they were raised. Others unrestricted and can go to any utility. So like with House Bill 21-1105, all those dollars are restricted to the utility where that money came from. So Xcel Energy, gas and electric customers, the dollars could only go out for Xcel gas and electric. So while there are all these separate vectors, there is just one unified program. And we work with a partner network of around 100 different nonprofits around the state. So like specifically in Denver, it'd be something like the Archdiocese of Denver through Catholic Charities, the Denver Public Schools FACE, which is the Families Community Engagement, Jewish Family Services, Denver Indian Center, Servicios de la Raza, Volunteers of America, Salvation Army. And those local agencies that are embedded in communities take in applications for energy assistance, process them, and then EOC remits that money back to the utility that we make the pledge on behalf of those customers. So there's complex funding sources, a wide network of partners, but it is one unified EOC energy assistance program.
Thank you for that. The other question I have for you is, does the party's proposed carryover, does that change your request at all for the $25 million to energy assistance program? Because in other words, are your concerns related to the IQ-DI program budget spend shortfall allayed at all by the party's proposal to carry over those funds? the capacity?
You know, oh, I'm sorry, didn't mean to interrupt
Please.
you.
Go ahead.
You know, I think especially after the testimony we've heard this morning about the difficulties in interconnection, it's not. So I think it's important to remember that the ICS gardens, only 51% has to go to income qualified. If we do not get the gardens to, you know, the very specific state of completion by midsummer, then the guaranteed benefit goes from 50% to 25%. So if we take half of 300, you know, it's 150. We're not really sure if we're going to get 50% bill savings or 25. Whereas the gardens that were in the current 22 to 25 plan would be 100% donated. And the savings that we targeted is about 50% bill savings. And that, from our numbers, is about $60 a month or $720-ish a year. So I think Mr. Cowan put it nicely when he mentioned that, you know, this program has a bridge. For us, the way we see this energy assistance proposal is as another bridge. So we've had 3 years and a month or so of basically nothing being interconnected. You know, from Excel's own discussion, it takes them multiple years to get these gardens in play. So these benefits to these customers, you know, like they quantified earlier, the 20 megawatt garden's about $2.5 million a year. From our wait list numbers of about 9,000 customers at that $720, that was about 3 million, or excuse me, 6 million or 6.5 million, sorry. And, you know, as of just recently, that number's up to about 9,500. So that number's continually growing of the wait list. So these customers are not receiving the benefits. It looks like they may not for many years. So the way we saw this is until such time as these ICS gardens are in play, producing, generating bill credits, this is a way to bridge the gap of the programmatic failures to deliver bill savings to these customers.
Okay, thank you. I appreciate that. And I think I know the answer to this question, but I would just like to get your testimony. From where would you want public service to pull the money to fund this energy assistance program?
Right. So we imagine it would be from the RISA. And, you know, I probably should have maybe been a bit more explicit in testimony, but I would imagine it would be coming from that surplus at first, because it stands to reason that you would be drawing down a surplus before charging customers additional money.
Okay, thank you. And just let me check one thing here. All right. I don't have any further questions for you. Thank you for your time. I don't know if Ms. Canelio, if you had any questions based off that.
I do not, but I neglected to move for admission of hearing exhibit 701, which Mr. Bennett mentioned some of those numbers from his supplemental discovery response. And I don't know if it needs to be pulled up, but I'd like to request that that be moved to be admitted into the record.
Any party object?
Yeah, I mean, one moment.
Mm-hmm.
Are you good? Okay. Thank you. While we navigate audio issues, the company objects at this point. I don't think that there was sufficient foundation laid on these, or I mean, an appropriate, relevant opening with Mr. Bennett to move this into the record. And again, as I believe, as we had noted through Mr. Cowan, the company does not necessarily agree or verify any of the information contained in here.
Could I respond, Your Honor?
Sure, go ahead.
I just want to point to my exchange with Mr. Cowan that EOC asked the company in discovery to quantify, you know, some of the benefits that have been provided to IQ and DI customers over the life of the current plan. And we admitted into the record the company's response that they don't have that analyses. And so the supplemental response can help fill that gap in the record where EOC's been, you know, quantifying some of the benefits that these waitlisted customers can achieve.
Okay, I appreciate both of your argument here. I'm going to go ahead and admit it over your objection. I do think it might contain information that can be useful when I'm crafting the decision, but I appreciate public services objection and concerns related to it, and we'll give it the weight it is worth when I take a look at it. Thank you. And then, with that, do we have any further? No more witnesses, or so I guess at this time we're done with the evidentiary portion of the hearing. So at this time, what I would just like to, does any party have any issue they need to raise before we conclude? And I'll talk a little bit about statements of position here in just a second, but does anybody have an issue they need to raise right now before we proceed with that? Okay. All right. Well, then I appreciate everyone's time today. I will take the matter under advisement and will issue a written recommended decision, of course. At this time, though, the parties, as you know, will keep the deadline was December 18th for the statements of position. And I know that had been set, but I think there had been a footnote that said there's a possibility that date would be changed, but we'll go ahead and keep that. I am particularly interested in the parties' positions on section 40-2-124 1G1D with respect to EOC's position relative to funding the Energy Assistant Program. And I also am interested, of course, in the parties' perspectives on the other contested issue. And I think with that, unless any other party, last chance, if any party has anything they need to raise or any questions, I see. Okay, Ms. Shields, yes.
We have not had the ability to kind of work with settling parties, but from time to time, settling parties are sometimes interested in doing joint statements of position. What I wanted to try to verify in advance is to the extent that there were parties interested in doing a joint statement of position around the settlement agreement, would you be open to potentially having a statement of possession with respect to the settlement agreement and then a separate briefing that addresses the litigated issues, if parties preferred such?
Yeah, no, I appreciate that question, and I would benefit from that. So I would appreciate that. That's fine with me if that's how the parties do want to proceed. I that would be fine with me. Appreciate
okay, thank
that.
you. Yeah, we will outreach with them. Like I said, we've not been able to have discussions around that, but just wanted to preemptively raise that in case we decide to go that direction.
Yeah, no, I appreciate that. Great. Does anybody have anything else? Any other questions? Well, thank you then, everyone, for your time. I really appreciate everybody's time and commitment to this matter, and I look forward to getting the statements of position. Thank you, everyone.
Thank you, Judge. Bye.
Thank you.